Suspension. ಎಷ್ಟು ದಿವಸ ಆಗಿತ್ತು? Suspend agi? In the month of December. In the month of December, next week happen. Inspection side. Got promotion. Sorry, tomorrow. But Wednesday happen. Please, not correct. Okay.
My lords, this monthly impleading matter, my lords have heard it at length. I'm led by Senior Counsel Mr. K.G. Raghavan. It was date given for 12th for it to be wrapped up and be reserved for orders. My lord was sitting in a different combination. At the request of senior, I'm mentioning today for 2:30, my lords. Only the rejoinder part is left. It's the impleading for monthly that arbitration has stopped completely, my lords. Both sides have argued in detail.
Correct.
It was date fixed for 12th. The different combination was sitting, so now there's no next date. It was supposed to be listed today automatically. It's not come up in the list. I'll hand over.
Yeah. For vacating up interim order here, arbitration process has been stayed.
Next week. Week after next happily. Next week agalla. Unmadikobeku.
Land grabbing case is concerned, my lord. The lordship has fixed the date for last week, my lord, but there is a different combination. It's not posted, my lord. The trial court posted 21st, my lord. Any 20th or
Different combination andre.
that means to say, lordship is sitting with the regular bench with the lordship, my lord.
Avaga.
20th, my lord. 21st, lord, the matter was fixed before the trial court, my lord.
Lord, this is a service matter, my lord. The petitioner has been terminated from a services.
Avaga.
My lord, the order was passed in 23/10/2023, my lord. Thereafter, she approached the KAT.
Week after next.
Lord, KAT approach agi notice issue agiti court.
Repatriations, my lord.
Repatriation.
Yes, my lord. In similar matter, already the tribunal has granted the interim order, my lord. In this applicant, in this case, my lord, the interim order is not granted, my lord. That's why you agree relieve madak kotidare. That's why, my lord, there is an urgency.
Pending matter.
Please, my lord, pending matter. But the interim order has not considered. The same has been rejected, my lord. Rejected by the tribunal. But in other similar matter, already granted the interim order, my lord. That's why. Yes, please.
My lords, fresh matter against State Commission order is listed for final disposal on 26th. It was date given again last week. Lordship was sitting in a different combination. I'm requesting 24th. It's 2 days before final disposal.
Good. Yes.
My lordship in service matter. Any date, my lord, next. 2023, my lord.
23.
Yes, ma'am.
Week after next.
Compulsory retirement punishment was imposed, my lords. Sorry, my lords. Compulsory retirement punishment was imposed, my lords. We have challenged the said order. Administrative tribunal passed the order in favor of us, my lords. Meanwhile, the state preferred an appeal. Where now, my lords, my pensionary benefits are withheld, my lords. It's the urgency.
Week after next.
Service matter of the year 2020 taken a week after next.
Okay, ಮುಂದೆ ಅಲ್ಲಿರುತ್ತೆ ಅಂತ ಯಾರೋ ಹೋಗ್ತಾರೆ ಆಗಲ್ಲ ಇದು ಆ ರೂಟಲ್ಲಿ ಆ ಸ್ಕಾರ್ಪಿಯೋ ಮುಂದೆ ಆಗತ್ತ
ಕ್ರಾಸ್ ಆಗಿದೆ
ಆಗಲ್ಲ ಹಿಂದೆ ಹೋಗಿ ಆಗಲ್ಲ ವಾಪಸ್ ಹೋಗ್ಬೇಕು ಕಾರು
Lords, this is the matter relating to Lord, the government undertook to file a review, my lord. It's being filed. It will be done in another 15 minutes, my lord. I'll get the case number. It may be taken up at 2:30 or. My lord, initially there was a decision taken to file a SLP, my lord. The matter in this matter, direction has been given to the official respondents to admit the appellant to grant in aid, my lord. And there is a factual error in this matter insofar as whether she was appointed to a sanctioned aided post or not. With respect to that, we have secured certain documents which were kept in the custody of the principal of the aided college, my lord. It was not with the officers. Those documents have been secured and documents relate to 25 years ago, my lord. Therefore, it took some time. It is being filed right away, my lord. It is. I should get the number.
File it is another thing, please. Right away, ಎಂದು ಸಹಿತ 12th June 2024 ಆಗಿದೆ ಆರ್ಡರ್. ಹೌದಾ? 12th June ಆದ್ಮೇಲೆ ಅದು ಎಷ್ಟು ಡಿಲೇ ಎಷ್ಟಾಗ್ತದೆ?
It's about 8 months.
Explanation. Why ಅಷ್ಟು ಆರ್ಡರ್ ಹಾಕೊಂಡು ನಮ್ದೇ ಆರ್ಡರ್ ಅಷ್ಟಾದ್ಮೇಲೆ ಹಾಕಿ ಇಷ್ಟು ಈಗ ಈಗ ಹಾಕಿರಿ ಏನ್ ಮಾಡೋಣ?
We have filed an application also for condonation of. Your lordships may recall in this matter, the principal secretary was summoned, my lord, on the last occasion.
That's all right. Outer limit of 3 months, failing which stringent action may follow against the erring officials ಅನ್ಕೊಂಡು ವಾರ್ನಿಂಗ್ ಕೊಟ್ಟೇವು ನಾವು. Read the page 9 of our order.
Please.
ನೀವು ಅಪ್ಲೈ ಮಾಡ್ರಿ, ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿವ್ಯೂ, ರಿಸಲ್ಟ್ ಆಫ್ ರಿವ್ಯೂ ಮಾಡೋಣ. ಏನು ಏನಾಗ್ತದೆ?
It may be taken up 2:30, my lord. It's being filed already.
ಅಲ್ಲ,
Everything
you
is
filed ಅಂತ
ready.
ಇಟ್ಕೊಳ್ಳಿ, 2:30 ಹಾಕಿ filed ಅಂತ ಇಲ್ಲ, June now. This compliance will be subject to outcome of the review petition. How you are sure that we are bound to succeed? We will assume that you are bound to succeed. Then this order will be set aside.
My lord, so my respectful submission that the erroneous factual finding, my lord, in fact, that is contrary to even an admitted position of the appellant, my lord. She admits that she was not appointed to a aided post. It will be forthcoming from the writ petition in
ಅಲ್ಲ,
pleadings in the writ petition itself.
aided post ಗೆ ಅಪಾಯಿಂಟ್ ಆಗ್ಲಿದ್ದಾಗನೇ admit the post to the aid ಅಂತ ಕೊಡ್ತಾರೆ ಆರ್ಡರ್. ಅವ್ಳು aided post ಗೆ
There are-
admit
was appointed to an
As
aided
a bit,
post.
my lord, there are two modes of entry into admission to a aided grant in aid, my lord. One is they should be appointed by following the selection procedure as prescribed in a 1981 order. And the conditions for selection are similar to the constitutional scheme for public employment.
ರಿವ್ಯೂ ಹಾಕ್ರಿ, ಅದ್ರ ಜೊತೆ ಕರಿತೇವೆ ಎರಡನ್ನು.
Agli sir.
ರಿವ್ಯೂ ಹಾಕಿ ತಗೊಂಬನ್ನಿ.
I'll give the number, my lord,
Pass.
shortly.
ರಿವ್ಯೂ ಹಾಕಿ ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳ್ಬಿಡಿ.
Please.
Post this matter along with the review petition in the making at the hands of the authorities immediately. Okay. ಎರಡು ಬಂದ್ಬಿಡಿ ನೋಡ್ಬೋದು, ಅದು ಒಂದೇ ಸರಿಗೆ ಮುಗಿದು ಹೋಗ್ತಾರೆ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಲ್ಲ, ಏನು ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಬೆಲೆ ಇಲ್ಲ, ಕೋರ್ಟ್ಗಳಿಗೆ ಬೆಲೆ ಇಲ್ಲ, ಎಂತದಿಲ್ಲ.
But we have
ನಾವು
explained,
ನಿಮಗೆಲ್ಲ ಬೆಲೆ ಕೊಡಬೇಕು.
there is an explanation for the delay, my lord. We have filed an application for condonation. of
ಬರ್ಲಿ
guilt.
ಬರ್ಲಿ, ಅವರೆಲ್ಲ ಇರ್ತಾರೆ ನೋಡೋಣ. ಬಟ್ ಈ ರೀತಿ ಆಗೋದಲ್ಲ, ವರ್ಷಗಟ್ಟಲೆ ಮಾಡ್ಕೊಂಡು. ಎಸ್, ಈ ಸರ್ಕಾರಗಳು ಮೊದಲು ಕೋರ್ಟಿಗೆ ಮಾನ್ಯತೆಯನ್ನು ಕೊಟ್ಟರೆ ರೂಲ್ ಆಫ್ ಲಾ ಉಳಿತು. ಸರ್ಕಾರಗಳು ಕೋರ್ಟಿಗೆ ಏನು ಮಾಡಲ್ಲ, ಅದು ವಿ ಕ್ಯಾನ್ ಟೇಕ್ ಫಾರ್ ಜಡ್ಜಸ್ ಫಾರ್ ಗ್ರಾಂಟೆಡ್, ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಸುಮ್ಮನೆ ಹಂಗೆ ಮಾತಾಡ್ತಾರೆ. ಇದೆಲ್ಲ ನಡೆಯಲ್ಲ.
Yes, I will try to explain the delay.
ಪೋಸ್ಟ್ ಮಾಡಿ.
But I appear for my lords B.A. Sachin. But I appear on behalf of Sachin, my lords, in the first matter, my lords, the petitioner, my lords, M.S. Huchegowda.
Ah.
My lords, he was expired, for which he brought LR application, my lords. We had not filed amended cost title. But we have carried out amendment, my lords, in the writ petition copy. But I'm filing the amended cost title, my lords.
ಅಷ್ಟೇ ಕಂಪ್ಲೈಂಟ್ಸ್.
My lords, I.
Amended cost title is filed. ಹಂಗೆ ಸರ್ವ್ ಮಾಡಿರ ಕಾಪಿನ
Lords, the
not
amendment
sir.
is allowed.
ಅಪ್ಲಿಕೇಶನ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಕೊಡಲ್ವಾ? Amended cost title. Wide order dated 20 September 2024 is filed today and the same is accepted.
My lords, 2.1, I had moved the memo. My lords,
2.1
that is not linked. I don't know why. It may be D-linked.
not concerned with this.
2.4, 36537 of 2017.
Not concerned.
Milords, I appeal.
2.1 is
0.4, Milords,
delinked.
for
Three-
respondent by 3.
2.4, my lords, 2.4.
0.4
36537 of 17.
D-tag to be D-tag. Yes.
Lords,
Here in 2.4,
If I may
Milords, for
submit.
respondent number 3.
Ah.
Seeking 1 week time, Milords. Let me post for the next week.
Wait.
Senior is in the other court, Milords.
ಅಲ್ಲೇ ಇರ್ಲಿಕ್ಕೆ. Start.
lords, matter relates to departmental inquiry.
People are laughing at us. Ready? Yes, sir. Start.
Senior is having typhoid, my lord.
ನೋಡಿ 2015 ಎಷ್ಟು ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ ನೀವು ಹಂಗ್ ಮಾಡ್ಕೋತ ಹೋದ್ ನಾಳೆ ನಮ್ನ ಕಾರಿನಿಂದ ಕೆಳಗಿಳಿಸಿ ಜನ ನಾವು ಹೊರಗೆ ಅಡ್ಡಾಡೋದು ಇರ್ತದೆ, ನೀವು ಅಡ್ಡಾಡ್ತಿರಲಿಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲ ನಂಬಿಕೆ ಹೋಗ್ಬಿಟ್ಟದೆ ಈಗ. ಬರೀ ಈಗ ಎಂತದರ ಆರ್ಡರ್ ಮಾಡ್ರಿ ಅಂತಾರೆ ಜನ. ಮೊದ್ಲು ಚಲೋ ಆರ್ಡರ್ ಮಾಡ್ಲಿ ಅಂತ ಅನ್ಕೊಂಡ್ಬೇಕು, ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಹಿಂಗೆರೆ ಮಾಡಿ ಹಂಗೆರೆ ಮಾಡಿ. ದಯಮಾಡಿ ಇಡಬೇಡ್ರಿ, ನಾವು ಸಾಕಾಗಿವಿ ನಿಮ್ ಸಲುವಾಗಿ ಅಂತ. ಪಾರ್ಕ್ ನಲ್ಲಿ ಅಡ್ಡ ವಾಕಿಂಗ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗತ್ತೆ ಮುಂಜೆ ಏನ್ ಮಾತಾಡ್ತಾರೆ ಜನ ಅನ್ನು. 10 ವರ್ಷ ಆತಿದು ಕೇಸ್. ಏನಿದೆ 10 ವರ್ಷ ಇಟ್ಕೊಳ್ತೇನೆ, ಕೇಶವಾನಂದ ಭಾರತಿನ ಇದು. ಆರ್ಗ್ಯೂ.
Next week, my lord, senior will come. Senior is in typhoid, my lord, they recorded. It requested my lords before.
ಇನ್ನು ಉಳಿದ ಮ್ಯಾಟ್ರಸ್ ಯಾವ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಟೈಪ್ ನಿಮ್ದೆ
3653 of 17. I'm ready.
ಆರ್ಗ್ಯೂ. ಯು ಆರ್ ರೆಡಿ ಇನ್ ದ ಮ್ಯಾಟರ್? ನಾಟ್ ರೆಡಿ?
I need time, my lords.
now good best time.
My lords, another matter is posted in series. We'll have to run there. That's the reason I'm asking time, my lords. Kindly give at least 2 days time, my lords. Please, my lords.
ಇದು 2015 ಯಾವಾಗ ಕರಿಬೇಕು?
Next Monday, they got next Tuesday, 25th.
Tuesday ke 18, Monday ಮತ್ತೆ Thursday ke.
25th. Reluctantly adjourned to 25th. 25th. Since lawyers are not much cooperating.
Let's, I'm ready.
With one or the other ground. Yes.
Much obliged.
With one or the other pretext. Okay. Yes.
Fast or minute.
Pass.
Yes, I appear in 4.1 for the respondent. Respondent number 1 has passed away, Mr. R. Swaminathan. I appear for the respondent in 4.1, my lord.
Respondent 1 is dead now.
Please, my lord. Shri Kalapa. I seek a week's time to place the copy of the death certificate and memo on record, my lord.
Same respondent ನಿಮ್ದ್ರಲ್ಲಿ.
Respond, I'm petitioner number 1.
Correct. ಅದೇ respondent.
ಇಲ್ಲ ಅವ್ರ
4.1.
My lord, the first petition is filed by private respondents. Who were unsuccessful before the applicant.
Second is by the authority.
Second is by the state.
Statement.
In both the cases, my lord, they seek regularization on the basis of parity with those who were regularized based on a government order dated which was issued in 1990. And that government order.
90.
Yes, my lord.
Okay.
That government order came to be issued pursuant to a direction of the Honorable Supreme Court.
Daily
in Harvard
wages, yes.
PWD Literate Daily Wage Employees Association case, my lord. That is the first judgment which is overruled in Umadevi's case. So therefore, blood, in Umadevi's case, it is also held there can be no regularization on the basis of parity in each case, whether they fulfill the conditions prescribed in para 53.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡ್ಯಾರ? ಉಮಾದೇವಿ has further more ಕೇಸರಿ ಇದೆಲ್ಲ ಬಂತಲ್ಲ. How many years they have put in service?
My lord, it's more than
appointment on
they have been appointed prior to 1990. my lord.
Correct. Regulation order ಮಾಡಿದಾರ ನೋಡು.
no
In one case, they have,
regularization.
in the petition filed by the state, my lord, the applicants have succeeded.
Applicant has succeeded.
They are from the Department of Animal Husbandry, my lord. They were
83 ಇಂದ
They
work
were-
ಮಾಡ್ಯಾರ.
Labor.
1983 ಇಂದ. Daily wages ಬಂದಿದ್ದು 1989 judgment ಬಂದಿದ್ದು. Then you pass it 690 order to implement this one.
Please, ma'am.
The decades thereafter, Uma Devi came.
Please.
Why you did not comply with 6890 order?
My lord, these were not the beneficiaries of 6890 order.
No issue.
No, I am
They
the
are saying
beneficiary. I am the
that they
beneficiary.
are similarly situated to those who were regularized pursuant to that order.
Anyway, 1983 ಇಂದ ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ರು?
My lord,
I am asking a question. ಅಲ್ವಾ?
it's certainly more than 10 years, which is the
ಹಂಗೆ ಹೇಳ್ಬಾರ್ದು. 83 ಇಂದ 10 years ಅಂತ ಹೇಳ್ಬಾರ್ದು.
42 years.
ಹಾ, ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಅವರೆಲ್ಲ ಲೋವರ್ ಸೆಗ್ಮೆಂಟ್ ನಿಂದ ಬಂದವರು ಇರ್ತಾರೆ. ಡೈಲಿ ವೇಜರ್ ಬರೋದು ಅಪ್ಪರ್ ಸೆಗ್ಮೆಂಟ್ ಯಾರು ಡೈಲಿ ವೇಜರ್ ಆಗೋದೇ ಇಲ್ಲ.
my lord,
ಅವ್ರು ಏನೋ 40 ವರ್ಷ ಗಟ್ಲೆ ಕೆಲಸ ಮಾಡಿದವ್ರಿಗೆ ನೀವು ಉಮಾದೇವಿ ಕೇಸ್ ಹಂಗೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ವಾಪಸ್ ಕಳಿಸ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಏನಿದೆ ಅದನ್ನ ಮಾಡಿ ಕೊಡ್ಬೇಕಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಡಿ.
Your lordship pattern is
ಹಾ, ಏನದು?
forward by your lordship.
ನಮ್ಮ ಪೋರ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಸ್ವಲ್ಪ ಉಳಿಸ್ಬೇಕು. ಎಸ್.
It is that, madam.
Huh?
Sanction post is not there ಅಂತ ಹೇಳ್ತಾರೆ. Sanction post ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸ್ಯಾಂಕ್ಷನ್ 40 ವರ್ಷ ಗಟ್ಟಲೆ ಕೆಲಸ ಮಾಡಿಸಿ ಯಾಕೆ ಮಾಡಿಸಿರಿ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲಿದ್ರೆ?
My lords, if I may place
My
one
lord,
submission on record,
Hindu-
the similar laborers in the case of Imam Hussain and B. Timmana, they were also given the same pensionary benefits. They were also working in the same post alongside the very same applicants. They were also given their applications, their representations were allowed. But for us, it was denied on no basis. In fact,
the KCT has categorically stated that there is no reason for why they have denied these benefits to me when I'm similarly placed and similarly situated, madam.
ಫಸ್ಟ್ ಕೇಸ್ನಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ? 42 years. ಅದರದ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ?
Maloj?
29/1983 appointment.
29/1983. Where is your objection reply statement, brother? ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಹಾಕಿದ್ದು ಗವರ್ಮೆಂಟ್ ಮುಂದೆ.
Case number 81, 81.
81 ನಾ? ಸರಿ ಮಾತಾಡ್ಬೇಕು.
Yes, madam. Annexure. ಇಲ್ಲ, ಅದು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈಲ್ ಬೈ ಅವರ್.
ಅಲ್ಲಿ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರಾ?
Reply statement is not filed even then.
Not filed.
My lord, there is an endorsement, my lord, annexure A5, A6 and A7 rejecting the claim of the A5, my lord.
Case number 63, madam. Annexure C is the reply statement filed by the statement before the case number 63. Number 4, madam. Is true that several railways have been regularized under the government order dated 6.
ಅಲ್ಲಿ ಮೈಕ್ ಇಟ್ಕೋಬೇಕು ಸ್ವಲ್ಪ, ಮೈಕ್ ಇಟ್ಕೊಂಡು ಓದ್ಬೇಕು. ಮೊದಲೇ ಈ ಕೇಸ್ ಮತ್ತು ವಾಯ್ಸು
6890, my lord.
ಪೇಜ್ ನಂಬರ್ ಏನು?
Page number 64, madam. 63 is the annexure C reply statement.
ರಿಪ್ಲೈ ಹಾಕಿದಾರಲ್ಲ?
Yes, madam.
Lord, it has been rejected on 2 grounds, my lord. One is that they have not been appointed against sanctioned posts. The other is that, my lord, they have not continued in service without the intervention of court orders.
Because of labor courts order they continued ಅಂತ. ಅದು
Those are the two
6890
reasons which are
requirement.
given.
6890 requirement. So you have applied 6890 order.
Lord, the conditions prescribed in para 53 of Umadevi's judgment, there are 5 conditions, my lord.
Should
The-
not have,
the
should not,
initial-
should continue without intervention of the court order.
The first condition, my lord, is whether the initial entry was irregular or illegal. And the court has, the constitution bench has categorically held that if the initial entry is illegal, then the fulfilling the other 4 conditions will be irrelevant.
Illegal,
No length of
illegal
service.
ಅಂದ್ರೆ ಏನು?
My lord, please, my lord.
But when you call it illegal?
Please, my lord, I'm grateful for that question, my lord. My lord, we have to refer to the earlier paragraphs in Umadevi's case to understand what is illegal and irregular, my lord.
Yes.
It has been clarified that when an appointment does not follow some technicality in the procedure, which does not offend Article 14 and 16 of the Constitution, which is equality of opportunity in public employment. That is, appointment should be through open competition, merit and reservation, my lord.
ಅಂದ್ರೆ ಯಾರನ್ನೂ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಲೇಬಾರ್ದು ಅಂತ.
No, there are cases when these conditions are fulfilled, my lord. If they are done through, my lord, in fact, your lordship are aware of Nihal Singh's case, my lord. In which case,
we have followed in
Indeed.
Dharwadನಲ್ಲಿ we have followed that.
Indeed.
We have explained the Nihal Singh also.
indeed, my lord. In that case, the Honorable Supreme Court has carved out an exception to one of the conditions for regularization. That is, they should have been appointed against a sanction. Carved out is the finding in Nihal Singh's case that initial entry is not illegal. Therefore, having continued for them for a very long period of time, the government cannot take advantage of its own wrong by saying that it did not create sanction vacant posts.
Correct.
In fact, the expression used is sanction posts will not fall from heaven.
Correct.
When you knew that the services are perennial in nature and you required their services, you should have created. So therefore, an exception is carved out. My lord, be that as it may, my lord, in this case, the initial entry itself is illegal.
ಯಾಕೆ?
My lord,
If that was so,
please.
rest of the people who gained entry, ಅವರನ್ನು ನೀವು ಇಲ್ಲಿಗಲ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿಲ್ಲ. ಪೆರಿಟಿ ಬಿಡಿ.
Please.
Perity argument is another thing. We'll treat it separately. The persons whom you have regularized,
Please.
ಅವ್ರಿಗೆ ಯಾಕೆ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ?
That was prior to Umadevi's judgment, my lord. Those
ಇದು ಅವ್ರ ಜೊತೆನೆ ಮಾಡ್ಬಿಟ್ಟಿರಿ, ಪ್ರಶ್ನೆ ಹೇಳ್ತೀರಿ.
ಅಲ್ಲ ಇದು
Had you done this with those people who all gained entry to the gate? Is it? ಅವ್ರಿಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಆ ಪ್ರಶ್ನೆಯನ್ನ ಬರ್ತದೆ. ಉಮಾದೇವಿ ಬರ್ತದೆ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ದೇವಿ ಬರ್ತದೆ, ದೇವ ಬರ್ತದೆ. ಅದಕ್ಕೆ ನಾವು ಕಾಯ್ಕೊಂಡು ಹಿಂಗಾಗಿ.
May I just point out this one observation in
No,
in para 5, my lord, it is noticed.
We understand you are very.
We understand.
ಅವರಿಗೊಂದು ಆ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ, ಧಾರವಾಡ ಕಾಪಿ ಕೊಡಿ.
These are persons appointed.
This ಈಗ ಲೇಟ್ ಆಗಿ ಬಂದಿರಿ, ಸ್ವಲ್ಪ ಗೊತ್ತುಕೊಳ್ಳಿ. Come to page 2.
Please.
Read page, para 2.
From the beginning, my lord.
Argument.
Para 2. Learned government advocate appearing for the appellants vehemently argues that the impugned judgment is liable to be voided since direction for regularization as such cannot be granted, and added firmly in the judgment is in specifying the post in which the employee should be deemed to have worked. The rulings invoked by the learned single judge, namely Nihal Singh versus State of Punjab, is falsome. So arguing he seeks.
So
allowing-
same argument is done by your counterpart at Dharwad. Okay, just
No,
400
I'm
kilometers.
saying something different, my lord. Certainly not what has been submitted here. What I'm saying is Nihal Singh is, my lord, absolutely right, my lord. There are several judgments of this courts beginning from 2012, my lord. In fact, I have taken shelter under this case when I was on the side of the private parties, my lord. In that particular case, my lord, the initial entry was in accordance with the rules. The only the thing that was irregular was that their appointment was made on contractual basis. My lord, Umadevi's case is, my lord, it may be mostly remembered for laying down the law that illegal appointments can never be regularized. It's a balanced judgment, my lord. It also lays down that if appointment is not made in accordance with the constitutional scheme, if security of tenure is not given,
Correct.
then it amounts to violation of Article 16 and 14. That is also stated, my lord. In para 6, it is stated in Umadevi's case, my lord. But the fact remains, my lord, in Nihal Singh's case, there was a categorical finding that the initial entry was not illegal. That is not the case in these cases, my lord.
ಇಲ್ಲೆಲ್ಲಿ illegal ಇದೆ?
My lord, they were not, my lord, it is for them to demonstrate.
ಒಬ್ರಿಗೆ ಇಲ್ಲಿಗಲ್, ಇನ್ನೊಬ್ರಿಗೆ ಇಲ್ಲಿಗಲ್ ಆಗಲ್ವಾ?
ಅಲ್ಲ, ಅವ್ರಿಗೂ
Because if the state were to be uniform, saying that all these people are jolted heads, we can agree.
my lord, in para 4,
Some are Socrates, some are jolted. On what basis?
my lord, the
Suppose-
answer to that question is in para 14 of Umadevi's case, my lord, wherein it is held that there is no equality in illegality. Otherwise, it would amount to jettisoning.
Where is the illegality?
My lord, the word used is it would amount to jettisoning the constitutional scheme for public employment.
Fully in agreement with what Apex Court has. Whether we agree or not, we are bound by what the Apex Court says. But question is, what will bind us? If entry were to be illegal,
Yes.
how is that you regularize the services of rest of the people who gained entry with him, with her?
My lord, that was prior to the decision in Umadevi's case, my lord.
That-
Therefore,
That's answered already. We have answered that. Kindly come to
Please.
para 4 of the judgment.
para 4.
That lawyer advocate was also equally vehement,
Please.
like you.
Having,
We appreciate that.
no,
No,
only,
we appreciate that. Well, otherwise state will be always at the receiving end.
my
only.
lord, the
But,
only,
at least
my lord, I
our
understand,
court-
my lord, I must point out, my lord. In fact, the state of Karnataka has indeed shown benevolence to contractual appointees, even in the teeth of Umadevi's judgment. When in cases where they could not be regularized, my lord, they don't fulfill the conditions laid down in
ಮೂರು
March.
ವರ್ಷ ಮಾಡ್-
particularly for-
Simple ಅರ್ಥ ಆಗಲ್ಲ. 43 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದವರಿಗೆ
My lord, there is-
ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ,
there is-
ನೀವು ಹಾಗಿದ್ದೀರಿ,
there is a
ನೀವು
scheme.
ಓದಿದ್ದೀರಿ, ಹಂಗೆ ಹೇಳಿ ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ where is the rule of law?
I'm just trying to point out, my lord. The state has tried to give them security of tenure by bringing the Daily Wage Employees Welfare Act of 2012, my lord.
ಅದು ರೆಗ್ಯುಲೇಷನ್ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
Regularization ಯಾರ್ಗ ಆಗಲ್ವೋ ಅವ್ರಿಗೆ ಡೈಲಿ ವೇಜ್ ಎಂಪ್ಲಾಯೀಸ್ ವೆಲ್ಫೇರ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ತಂದು they will be given minimum security of tenure until superannuation
Which is the
and the
latest, Mr. Joyce? which is the
2012
latest-
legislation.
Latest judgment which Apex Court,
Latest judgment.
latest body. They
My lord,
say
Jaggo's case, my lord.
cases of regularization do not fit into 2012 Act at all, which it came into force in 2013-14 ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ.
But on 16/25, I have filed the latest judgment on 16/20/2025 along with the memo, my lord, lordship have got. Jaggo versus Union of India
My
under.
lord, even in that case,
Along with
Jaggo's case, my lord,
1625. Because Umadevi has been more often abused by the state rather than being implementing. That is the
abused,
decision
my lord,
of
may I
Supreme
just point out, abused by applying Umadevi's
Court. It is the
judgment
para 26 of.
not to regularize
the
irregular
judgment.
appointments.
Ah.
That is what is pointed out in Jaggo's case. my lord. Irregular appointments ಗೂ ನೀವು ಉಮಾದೇವಿ ಕೇಸ್ ಅಪ್ಲೈ ಮಾಡಿ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ, ಅದು ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ದಾರೆ. It has only reiterated what is stated in
Filed on
para
63.
53, my lord.
ಹಲೋ ಅದು ಇನ್ನೊಂದು ಇದ್ರದ್ದು ಅದ್ರ ಮೇಲೆ ಏನಾರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಸಪರೇಟ್? ಅದಲ್ಲ ಇದಲ್ಲ ಆದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗಬೇಕು.
But the state's contention of these, my lord, may I just.
We'll consider it. We'll also say.
One is that they are seeking parity with those who were regularized as per the order passed in the overruled judgment, my lord, pursuant to the overruled judgment.
Dismissed. Okay.
The other is that initial entry is not illegal and not irregular.
Next. Yes. Yes.
Challenge not is to the order passed by the tribunal.
Ah.
And against not the DGO filed application before the tribunal challenging the penalty order of withholding of 20% pension for a period of 5 years.
214(1) B ಆಗತ್ತೆ.
2B, yes,
2B.
yes, pursuant to that. The matter arises out of not
Yes.
a case of alleged case of misconduct as per the articles of charge. The misconduct not is 6 DGOs. Not the inquiry not was held against 6 DGOs. Not before I proceed further, I would also request not to consider DGO number 4 not had approached tribunal. He was granted benefit. We challenged that order before this on court. This on court coordinate bench has rejected my writ petition.
Rejected.
DGO 4.
But identical fact matrix.
Not the designations are different. Not the facts are like this. Misconduct is not in relation to one road ಅಲ್ಲಿ ಇವ್ರು ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ಆರ್ಡರ್ ಇದ್ದಿದ್ದು ಇನ್ನೊಂದು ರೋಡ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಬಿಟ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಬುಕ್ ಅದು ಇದೆಲ್ಲ ಮಾಡಿ ಅಮೌಂಟ್
ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಆ ರೋಡ್ ಬದಲಿ ಈ ರೋಡ್ ರಿಪೇರಿ ಮಾಡ್ಯಾರ. ಅಟ್ಲೀಸ್ಟ್ ಅದು ಅಷ್ಟರ ಆಗಿದೆ.
DGO 4 not is the assistant executive engineer. DGO 4 is the assistant executive engineer who got the benefit.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿ?
Not WP 10130. I'll pass it on.
ಬಡಿ ನೋಡ್ರಿ ಅದೊಂದು ಪ್ರಿಂಟ್ ತೆಗಿರಿ. WP ಹೇಳಿ. Yes, brother, which is that judgment?
629.
Coordinate bench considered merits ಮೇಲೆ consider ಮಾಡಿದ್ದಾರೆ.
WP 10130. Of 2022
Dated.
(19/12/2024).
ಕೊಡಿ ಪ್ರಿಂಟ್ ಕೊಡಿ.
But in that case, the DGO is assistant executive engineer.
No,
In this
except
case-
designation. But rest of the things go against you. Designation ಇಂದ ಗಿಲ್ಟ್ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಲ್ಲ.
ಅಲ್ಲ ಅವರು ವರ್ಕ್ ಮಾಡಿರ್ತಾರೆ, ಇವ್ರು ಸೂಪರ್ವೈಸ್ ಮಾಡಿರ್ತಾರೆ.
ವರ್ಕ್ ಆಗಿದೆ.
Great.
ಇಷ್ಟು ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. Dismissed in view of coordinate bench judgment dated so and so. Next. ಅದ್ರದ್ದೊಂದು ಕಾಪಿ ತಂದು ಕೊಡಿ ಅಟ್ಲೀಸ್ಟ್ ವೆಂಕಟೇಶ್. ಒಂದು ಕಾಪಿ ತಂದು ಕೊಡಿ. ಎಸ್ ನಮ್ ಕಳಿಸಿ.
Respondents.
ಮಹಾರಾಜ
This, we have to take steps, my lord.
ಏನದು
Weeks time may be granted.
I will undertake my lord to file wakalat for.
ನಾಗರಾಜಪ್ಪ that council accepts notice for respondents 1, 2, 6
and 15.
15. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
Lord, there are other 3 matters are there.
Dava?
3 matters.
ಕೊಡಿ. List along with.
WP number 9444.
ಬರ್ದು ಒಂದು ಸೈನ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಡೇಟ್ ಹಾಕ್ಬೇಕು, ನಿಮ್ ಸೈನ್ ಹಾಕ್ಬೇಕು.
Lord, Lordship, I
Pick ಮಾಡಿ
kindly,
ಹಾಕಿ. Call along with
My lord, post this matter in the next week.
week after next. Next.
Pension matter, my lord.
Week after next week ಭಾಳ ಜಾಸ್ತಿ ಇದೆ. Okay.
This matter, my lord, before the tribunal, my lord, Srimati CJ Geeta has appeared for response number 2, my lord.
Madam,
The director, CJ Geeta.
CJ Geeta.
Yes.
Tribunal.
Yes.
ಅಲ್ಲಿ ನಾವ್ ಹೆಂಗ ಇಲ್ಲಿಗೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಬೇರೆ ಲಾಯರ್ ಬೇಕು ಅಂದ್ಕೊಂಡಿದ್ದೆ. Await notice ಅಷ್ಟೇ.
Jilla Panchayat.
Jilla
Panchayat Bangalore. Await, because they are the contesting parties.
They are the contesting parties, my lord.
Await it.
Await it.
Await service of notice. Post immediately after service. Okay. 8.
It's WP number 26056 of 2024 is in Lords, paper 1 and paper 2, my lords, in respect of the sub-inspector's recruitment, examinations are taken in 2 papers, paper 1 and paper 2. Subject matter of WP number 26056 of 24 is paper number 1. The grievance is very short. The notification, original notification which invited the application specifically said, paper 1 will undergo second valuation or third valuation as the case may be. If there is a difference of 8 marks, it will be referred to the third valuation. That's essentially what it meant. Lords, by virtue of certain allegations as to the manner in which the exams were conducted, or otherwise the candidates, my lords, had used certain dubious methods to get themselves recruited, secure higher marks. The examinations were cancelled and re-examination was conducted. When the re-examination was conducted, it was given to KEA. KEA did not make applicable, my lords, this principle in the notification. Now, the same was challenged before the KAT. KAT is no specific direction to the right. That is only grievance. Not the Supreme Court says that the instructions in the notification is mandatory and is enforceable. That's number 1. And once the notification is there, merely because the change of examination authority, my lords, will not dispense with the requirements of the notification. That's the only short point.
Yes.
Paper 2.
Lord, I am appearing for the petition.
Yes. Paper 2, nalla.
My lord, paper 1 and 2.
We are hearing. Here is there. Instructions are binding. Merely because authority is changed. Instructions are not diluted. 53 Supreme Court.
That was by the single judge, but I last time I have it, 230 also, but
ಯಾವತ್ತು ಇನ್ನೊಂದು ದಿವಸ ಇರುತ್ತೆ, ಯಾವತ್ತು ರೆಡಿ ಇರ್ತೀರಿ ಹೇಳಿ, ಅವತ್ತು ಮುಗಿಸ್ಬಿಡ. ಹಂಗ ಎತ್ಲಾಗ ಒಂದ್ ಮಾಡಿ ಹಾಕ್ಬೇಕಷ್ಟೇ. ಸಿಂಪಲ್ ಇವು ಕೆಲ
Saturday is a working Saturday, my lords. If
Saturday, we are not likely to be
very well.
this one.
Next Monday,
Next Monday
Next Monday, my lords.
ಇಷ್ಟೇ ಕೇಸ್ ಅದು ಹಿಯರಿಂಗ್ ಏನು RFA ಅಲ್ಲ ಎಂತ.
Lord, in addition to this, the key answer, my lord, is apparently wrong. That is one of the grounds which we have raised. And there shall be, my lord, relook into.
No,
Please.
8.1. Sorry. Learned counsel appearing for the petitioner moves a memo seeking leave of the court to withdraw the petition. First up, memo reads as a learned AGA does not have learned AGA appearing for the authority and learned panel counsel appearing for the KEA do not have objections. Help with that? Objections for grant of leave to withdraw. First up, in view of the above, petition is disposed of as having been withdrawn.
Please,
with no liberty to revive. Yes.
My lords, I am for the impleading applicants in both the matters, my lord.
You were not before the KAT.
My lords, if we go to the KAT, again, it will lead to multiplicity, my lords.
Should happen on the Supreme Court.
In view of the urgency, we may be permitted to
This
at least.
argument is rejected by the apex.
No, we may be permitted to assist this honorable
We
court.
don't need your assistance. There are advocates, there are parties. If you want to go, suffer an order, come here. This is what the scheme is now.
Please, my lord. And serial number 21, my lords.
the government has already, my lord, selection is made, some students are, my lord, undergoing training.
Training.
Yes.
And that is the urgency, my lord.
what has happened is
Reading application in IA number so and so is liable to be rejected since the applicants had not approached the KET but seek to gain entry to the list through another route which is impermissible. Ordered accordingly. Next. ಯಾವ application ನೋಡ್ಕೋಬೇಕಲ್ಲ? Yes.
Lord, I seek a Passover, my lord.
Passover.
For the petitioner, my lord.
Parashram.
My lord, the order, my lord, of the case that is challenged, my lord, where.
ನೀವು ಮಾತಾಡೋದು ಎಲ್ಲರಿಗೂ ಕೇಳಬೇಕು.
So, sir. But the order, my lord, where interim order has not been granted by the case, my lord, that is under challenge before your lordships, my lord.
Main matter is pending there.
Main matter is pending.
ಏನು matter?
Only difficulty, my lord, is that in the final list, my lord, somebody who's less meritorious than me has been included in the final list. Demonstrable. Can I just show your lordships?
ಅಲ್ಲ ಅದನ್ನ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬಿಡುತ್ತೆ ಟ್ರೈಬ್ಯುನಲ್ ಬೇಗನೆ ತಗೊಂಡು ಮುಗಿಸ್ರಿ.
My lord, the difficulty is the appointment order ಕೊಟ್ಬಿಟ್ರೆ I will be left to, my lord, third party.
That will be list pendants ಆಗ್ತದೆ.
My lord, I kindly say appointment order not be issued in respect of these two candidates only. That's the only. I'll demonstrate, my lord.
ಅಲ್ಲ, you want to demonstrate. We are agreeing with you. We will request the tribunal to decide. Otherwise, we become the tribunal.
No, my lord.
Which is L. Chandra Kumar does not permit us.
My lord, my request is, my lord, that the appointment orders be kept in abeyance. That's appointment orders, my lord, may not be issued, my lord. That's my only request.
Appointment order issue ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇನ್ನು ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಹಾರಿಜಾಂಟಲ್ ಅಂಡ್ ವರ್ಟಿಕಲ್ ರಿಸರ್ವೇಶನ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಇವ್ರಿಗಿಂತ ಇದರಲ್ಲಿ ಇರೋದು ಕೊಟ್ಟಿರೋದು. ರಿಸರ್ವೇಶನ್ ವಾಸ್ ಫಾಲೋಡ್.
ಇದನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕಾಲ್ ಮಾಡ್ತೀವಿ, ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಆಗ್ಬೋದು ಸರ್.
Okay?
ಆಗೋದು.
Let the state undertake not to give appointment orders till then. That's my only request. But then, my lord, matter become infructuous. My lord.
The vehement submission of learned counsel for the petitioner that the respondent should be restrained from issuing appointment order does not much impress us, in as much as should such appointment orders be issued, the same shall be list pendants. List pendants. First, in view of the above, petition is dismissed. Yes, next.
May I request, my lord, that the tribunal, some direction to the tribunal today.
However, we request the honorable tribunal to take up this matter bit expeditiously. Consistent with the rule of speedy justice being a constitutional mandate.
So good.
All contingencies kept. Yes.
I appeal for the accused in this matter.
Yes.
On last occasion, my lords had directed us to file the detail. My lords had directed us, my lords, to file the details of what are the payments made, pension when it was paid, all those. May I just pass on this memo, my
But
lords.
ಅವ್ರಿಗೂ ಕೊಟ್ಟಿರಾ?
ಇಂದ ಕೊಡ್ತೀವಿ.
ಅವ್ರಿಗೂ ಕೊಡ್ಬೇಕು.
My lords, here, my lords, the main grievance now of the complaint is that, my lords, that there is delay in payment, my lords, and they say that.
IRS officer
ಹೌದು.
retired and thereafter some orders are passed saying
ಹೌದು,
that
ಹೌದು.
this should be settled, etc.
Certain promotion was given from previous date, my lords, and subsequent also.
Well,
Only grievance is, my lords, revised pension and interest is not paid is what is the contention now raised.
interest is not paid.
Interest is not paid ಅಂತ ಇದೆ.
Order for payment of interest ಅನ್ನೋದು ನಿಮ್
Interest
content.
ಇಲ್ಲ, ಅದಲ್ಲದೆ ಡಿಲೇನೂ ಇಲ್ಲ, that I will just point out, my lords. If my lord sees the first page, this has the details of what were the.
Let us see the order, impugned order.
Please.
Order, why that order in question, whose violation is complained of.
They have filed one IA for revival, my lords, that may be seen, my lords, that has the order.
Read SLP nu dismiss ಆಗಿದೆ.
Dismiss ಆಯ್ತು.
Come to para 2.
Please, my lords.
ನಮ್ಮ ಆರ್ಡರ್ ಇದು.
Yes.
ಹೌದು, ತಮ್ಮ order. So, learned ASGI submits that insofar as the second part of the direction is concerned, namely conducting of TPC for considering the complainant candidature for further promotion, namely Chief Commissioner of Income Tax, there was some difficulty. The CAT order was challenged in WP number so-and-so, and the division bench dismissed the same on 21/4/2021. Review petition number 81 of 22 also met with no success by the order dated 13/12/2022. Thereafter, the matter was carried to the apex court in SLP number so and so, disposed of on 6/7/2023, and that also met with the same fate. In these circumstances, second direction remains uncomplied with, and the entire process will be completed if the period of 3 months is granted. We appreciate the difficulty of the official respondents. However, it is they who have lodged the challenge to the orders of the CAT before the coordinate bench in writ petition, followed by review petition, and ultimately followed by SLP. Be that as it may, justice of the case warrants that a period of 2 months can be granted for accomplishing the compliance of
Second direction.
second direction.
Which is that direction?
I'll point out with this memo entirely, my lords.
Okay.
It is done. I'll just point out.
ಅಲ್ಲ ನಮ್ಮ ಆರ್ಡರ್ನಲ್ಲೇ ಸೆಕೆಂಡ್ ಡೈರೆಕ್ಷನ್ ತೋರಿಸಿ.
ಹೌದು.
Where is that direction?
Lords, that is available at page number 4, my lords.
Page 4 of
Please, my lords.
contempt petition.
Memo, my lords.
Memo.
ಹೌದು. ಇಲ್ಲ ಈ ಮೆಮೊನಲ್ಲಿ ಒಂದ್ಸರಿ ತೋರಿಸ್ಬಿಡ್ತೀನಿ. ಡೀಟೇಲ್ಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಕ್ಲಿಯರ್. Lords, first page ತಾವು ನೋಡಿದ್ರೆ it has got details of what were the matters filed, my lords. First is the tribunal order. Second is this Honorable High Court's order, my lords. Then the RP order. Then SLP order. SLP was dismissed on 6/7/2023, my lords. And this was the contempt order on 15/12/2023, my lords.
Correct.
If my lord sees the second page, my lords, it has got the service details, my lords. Date of joining of the complaint was 16/12/1985. Date of superannuation is on 30th of November 2018, my lords. She retired in the year 2018. My lords, these are the details of payment which have been made in time, my lords. At that time, she was working as PCIT, my lords, Principal Chief Income Tax Commissioner, my lords. My lords, all the payments have been made, my lords, at the time of retirement, and she was heading as the head of the department also. Next page, page 3 in the tabular column, nodre, this is with respect to the, my lords, there was an order by the tribunal to give effect to that post, my lords, from previous 2 years, my lords. ಅವಾಗ ಮಾಡಿದಾಗ ಅರಿಯರ್ಸ್ ಏನ್ ಬಂತು ಅದು ಪೇ ಮಾಡಿದಿರಿ.
2,71,140.
ಆಫ್ಟರ್ TDS ಏನ್ ಬಂತು ಅದು ಪೇ ಆಗಿದೆ ಸ್ವಾಮಿ. This was as per the contempt order also we said we'll pay it on by on or before 15/1/24. We have paid it on 4/1/24. Differential the pension then ಬರಲ್ಲ ಯಾಕಂದ್ರೆ she was holding the same post. Only the arrears part it is paid, my lords. Next, my lords, we'll see on the page 4 tabular column, my lords. This has got, she was promoted to the Chief Commissioner of Income Tax, my lords. That order was passed on 1/10/2024. Difference has been paid. Arrears of pay of difference is also paid, my lords. And revised pension order is also issued. And if my lord sees the last page, my lord.
On 24/12/24.
ಹೌದು. ಅದು ಸ್ವಲ್ಪ ಕರೆಕ್ಷನ್ ಇತ್ತು ಮತ್ತೆ ವಾಪಸ್ ಬಂತು ಮತ್ತೆ ಕಳ್ಸಿದ್ರಿ. ಅದಾದ್ಮೇಲೆ ಪೇಜ್ 6 ತಾವು ನೋಡಿದ್ರೆ ಅಲ್ಲಿ ಪೆನ್ಷನ್ ಆರ್ಡರ್ ರಿವೈಸ್ಡ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರಿ. ಇಶ್ಯೂ ಆಗಿದೆ. ಪೇಜ್ 6
2/1/25.
ಹೌದು. ಅದು ಪೇಜ್ 6 ನಲ್ಲಿ ಅದು ನಮ್ಮಿಂದ ಕಳಿಸ್ತೀರಿ. ಆಮೇಲೆ ಪೆನ್ಷನ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ಆಗಬೇಕು. ಪೇಜ್ 6 ನಲ್ಲಿ ಫಸ್ಟ್ ತಾವು ನೋಡಿದ್ರೆ 7/2/2025 even the intimation is gone to their banker also, my lords. The banker is the Union Bank of India, MG Road branch, Bangalore. ಅದಕ್ಕೂ ಹೋಗಿದೆ. You would get that, my lords. So yes. When 2018 when she retired, my lords, all the benefits were paid.
What is the second direction which you undertook to comply with, madam? Which is that second direction?
To
CCIT.
hold a review DPC for the post of CCIT.
That is done, my lords.
Review DPC is done.
ಹೌದು, ಪೇಜ್ 4 ನಲ್ಲಿ ಇದೆ. ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿತ್ತು ಬಟ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ. ಪೇಜ್ 4 ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ CCIT promotional post as per the office order number 1st of October 24. ಅದು ಆಗಿನೂ ಡಿಫರೆನ್ಸಸ್ ಏನ್ ಬರುತ್ತೆ ಅದು ಕೊಟ್ಟಿದ್ದೀರಿ. ರಿವೈಸ್ ಪೆನ್ಷನ್ಗೂ ಕಳಿಸಿದ್ರಿ, ಅದು ಆಗಿದೆ.
Revised pension, I'll leave it to my lords. I am at your lordship's this thing, just to bring to your lordship.
Comply ಮಾಡಿದ್ದಾರೆ. Compliance.
Revised pension fix ಆಗಿರೋದು ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಅದು ಎಷ್ಟು ದಿವಸದಲ್ಲಿ?
Even ಅವರು review DPC which they had to hold, there is a delay. 8 months.
Review ಆಗಿಲ್ಲ. Review ಆಗಿದೆ. Review DPC ಆಗಿದೆ.
Order ನಲ್ಲೂ delay. ಅದನ್ನೇ ನಾ ತಮ್ಮ ಗಮನ.
No case is made out for revival in view of what has been stated in the memo filed this day by the learned ASG in 17, dated 17/3/2025, along with the full details which are reproduced for ease of reference. First, ordered accordingly and application is disposed of. Next.
Let them at least, Swami, let them release it. They have not released the revised payment. ಇನ್ನು release ಆಗಿಲ್ಲ. ಕಳ್ಸಿದಾರೆ
ಬ್ಯಾಂಕ್ ಬ್ಯಾಂಕ್ ಹೋಗಿದೆ
ಆಗಿಲ್ಲ.
ಬ್ಯಾಂಕ್ ಕಳ್ಸಿದೆ ಅದು ಇದೆ
Bank
ಇಂಟಿಮೇಷನ್
ಕಳ್ಸಿ ಮತ್ತೆ
they have to
ಅವ್ರಿಗೆ
approach the bank my lords if there is an
Anyway, we'll send one more reminder.
one more reminder also will
ಅಲ್ಲ,
send
It is their own department, Swami.
ಅಲ್ಲ ಬ್ಯಾಂಕ್ ನಮ್
Bank.
ಬರಲ್ಲ
ಯೂನಿಯನ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಕಳಿಸಿದ್ರು.
ನನಗ್ ಬರಲ್ಲ ಅದು
ಬ್ಯಾಂಕ್ ನಿಂದ ಇದು ಆಗತ್ತೆ, ರಿಲೀಸ್ ಆಗತ್ತೆ.
ಅಲ್ಲ, revised ಅಂತ
You send.
out
we
ಮಾಡ್ಬೇಕು.
will send a reminder also my lords once again to
In
them.
the meanwhile, we appreciably record the submission of learned ASG that a strict reminder would be sent to pension disbursing bank in accordance with the with the revised pension order RPO dated
No,
January 25. 7/2/2020.
23 order.
Registry shall send a copy of this order to the branch manager, Union Bank of India,
MG Road.
MG Road, Bangalore, forthwith by speed post.
That would
Ah,
that would
yeah,
be
that
helpful.
Next.
Much.
Nath. Then ಮೇಲ್ಗಡೆ order ASG, madam so and so, so and so. Okay.
It's a very, very short issue, my lords. The petitioners and the respondents were recruited together in the same recruitment process. Appointment orders were issued on 6/3/1997 with a direction to report within 15 days.
Yes.
The provision, that is Rule 18(2), lords, of the General Recruitment Rule provides that if there is any difficulty, the candidate can seek for extension of the period for reporting. So far as the petitioners are concerned, they reported within 15 days. So far as the private respondents are concerned, they gave a representation on 23/1997 that the extension was given, as a result of which one of them has reported on 5/4/97 and other has reported on 7/4/97, as against the reporting of the petitioners on 19/3/1997. Now, the only question is Rule 5(1) of the seniority rules.
ಲೇಟ್ ಆಗಿ ರಿಪೋರ್ಟ್ ಮಾಡಿದವರು ಸೀನಿಯಾರಿಟಿ ತಗೊಳ್ಬೇಕೋ ಬೇಡ
ಅಷ್ಟೇ ಪ್ರಶ್ನೆ. ಇದಕ್ಕೆ Rule 5(1) my lords completely determines.
ಕೊಡಿ. ಅವ್ರ ಮೇಲೆ ಯಾವುದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದ್ದೇನೆ, ವೇರ್ ದೇ ಹ್ಯಾವ್ ರಿಪೋರ್ಟೆಡ್ belatedly but with the leave of the government.
That is the chairman.
Andhra Pradesh Supreme Court.
What happened? Radhakrishna's case, Srinivas versus Radhakrishnamurthy's case, dealt with the rules of the Andhra recruitment rules. Let's have made a comparative chart of both the rules.
ನಮ್ಮ ರೂಲ್ ಏನ್ ಹೇಳ್ತದೆ?
In Andhra rules, there is no provision for extension. The matter which came up before the Supreme Court was the GO enabled the extension. When the GO was operated upon, and after 10-15 years, they wanted to say that this power itself is not there. That is where the Supreme Court said that there was no prohibition as such. GO permitted them. If that extension is granted, then it is permissible that you will have to count it from the date on which the extension has been given. But here the question is, Rule 5(1) of the seniority rules.
Let us see that. Read.
Lords, if your lords were to take the very same, at page 35, lords, Rule 5(2)
of paper book.
Of the paper book, because it's extracted in the orders of the KAT. I'll just read from page 34.
Notwithstanding.
Lords, I'll just read from page 34, lords.
ಅಲ್ಲ 34.
These are
Training time for appointment.
A candidate appointed by direct recruitment shall assume charge of the post specified by the appointing authority as soon as possible after the date of the order of appointment, but not later than 15 days from this day. For the purpose of this rule, the date of order of appointment means the date of dispatch of the order of appointment by registered post to the address given by the candidate. Notwithstanding.
ಅದು mostly dispatch and receipt ಅಂತ ಓದಬೇಕಾಗ್ತದೆ.
Yes,
ಈ dispatch ಮಾಡಿ 6 ತಿಂಗಳಾದ್ಮೇಲೆ ಬಂತು ಅಂದ್ರೆ.
Yeah, lordship. That also there is covered by judgment of the Supreme Court.
That's what. Yes.
Notwithstanding anything contained in sub-rule 1, appointing authority may, on an application of the candidate, and if satisfied there are good and sufficient reasons for doing so by an order in writing,
grant such a further
time as may deem necessary. This is the extended period. One is the period prescribed originally under Rule 18(1) of the General Recruitment Rules. 2 speaks about the extended period. Now, lords, my kindly see Rule 5(2). Notwithstanding anything contained in sub-rule 1, seniority of a candidate who assumed charge of a post after the period specified in sub-rule 1 of Rule 18 of the Karnataka so-and-so shall be determined as from the date on which he assumed charge of such post. This is conspicuously absent, my lords, in Andhra rules. Now, whether Rule 5, when 18.1 is very specifically spelled out and 18.2 is not referred to, my lords, under 5.2.
You mean to say 18, in the absence of 18.2, right to appointment would have been forfeited?
It would have been forfeited because the waiting list will be operated. Notice it's an extended period. One is the period prescribed under 18.1. That is a period by itself. Then there is an extended period. But what is
extension period?
Yes.
Saves the appointment, but not the seniority.
Not the seniority. That's all the point.
How courts have interpreted this?
That's the reason why I said not the KAT only says that by relying upon the judgment of Andhra High Court, page 38, it's extracted, my lords. It says that since the extended period was permitted under a GO, the reporting to the duty during the extended period will have to be counted as though he was originally appointed as on the date of the order of appointment. That is essentially, my lords, but there is no 5.2 there.
18.1 and 2.
Yes.
Have nothing to do with seniority at all.
Lords, 18.1 and 2 have nothing to do with seniority. 18.1 deals with because it gains significance because of the conspicuous mentioning of 18.1 under 5.2 of the seniority rules. 18.2 is not mentioned.
18.1 alone is mentioned.
Alone is mentioned.
Otherwise, they would have said 18 rule 2 also.
Yes.
Is your submission.
That's true, my lords.
How this is met by the tribunal?
Lords, the tribunal only says, without reference to rule 5.2, my lords, the matter is decided. It says that since the Supreme Court has taken a view with reference to the Andhra rules.
Andhra rules are not pari materia.
Andhra rules is not pari materia. I have given the comparative table.
Where is that?
Just pass it on, lords. Sorry. Yes.
Ida?
Howdu. ಅವರು ಕೊಡ್ಲಿಕ್ಕೆ
Sorry, sir. ಎಲ್ಲಿದೆ Andhra rules?
Lords, ಅಲ್ಲ ಇವಾಗ
comparative table. Convenience. Joining time for appointment 1, 2. Direct candidate selected for appointment by the recruitment shall be required. Join elections. After appointment, very important. Owning the time limit. If he does not join, shall be treated as automatically cancelled, and the name of the candidate shall be deemed to have been omitted from the list of approved candidates. The time to join a post appointment shall be allowed a joining time of 30 days after. Otherwise, stand by the recruitment shall be allowed term of 30 days from the date of receipt of. Where a person fails to join the new post, which is appointed within a set period. Shall forfeit his right of appointment both for the present and in future.
Then, my lords, seniority rules, my lords. Rule 33 of the Andhra seniority rules deals with this. Rule 5.1 and 5.2 I have read, my lords. In this, what your lords may have to consider is mark
18.2 has nothing to do with the seniority. 18.1 being mentioned in 5.2.
5.2
is your contention.
That is my contention. And lords, a person who seeks for extension takes the risk. Both, lords, a person who seeks for the extension, though there is a discretion vested for extension of such time, but he takes the risk, my lords, of foregoing the seniority in terms of Rule 5.2.
If he is under the impression, so also the government saying that extension ಕೊಟ್ರೆ seniority alter ಆಗಲ್ಲ ಅನ್ನೋ premise ಮೇಲೆ ಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಅವಾಗ ಬೇರೆ ಆಗ್ತದೆ. ಈ ರೂಲ್ಸ್ ಇವೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ವೈ ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ವೈ ಜೆರೆಮಿ ಬೆಂಥಾಮ್ ಸೆಡ್ law shows its face in mask ಅಂತ.
Mask.
ಇದನ್ನ ಕ್ಲಾರಿಟಿ ಇಂದ ಹೇಳಿದ್ರೆ ಇವೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್.
5.2, my lords, is very explicit and clear. My lords, if 5.2 had said that any person who has reported to duty under 18.1 or extended period under 18.2.
ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದ್ರೆ ಮುಗಿದು ಹೋಗ್ಬಿಡುತ್ತೆ.
Yes,
ಅದು ಹೇಳಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಇಷ್ಟೆಲ್ಲ.
Lords.
5(2) mentions 18(1) but not 2 ಅನ್ನೋದು ನಿಮ್ contention.
Lords, kindly have a look at page 86, my lords. It was made very explicitly clear in their appointment that your seniority is regulated under 5(2). Page 86.
ಅದು ಬಿಡಿ. That's how it.
No, my lords, it says you are under the extended period under 18.2. Therefore, you will be seniority will be reckoned in terms of 5(2).
5(2) which refers to 18(1).
18.1.
Not 18(2) ಅಂತ ನಿಮ್ಮ
So that essentially means from the date of let's post, you are assuming the
So
charge.
you have to take the seniority below your client ಅಂತ ನೀವು ಹೇಳೋದು.
That is all. And from the date of assuming the charge, the seniority list has to be drawn up. Page 86 minutes, if I were to just read it. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಅಭ್ಯರ್ಥಿಗಳು ಮತ್ತು ಮನವಿಗಳಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ typed copy. I'm sorry. Page copies, typed copies at page 87. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದನ್ವಯ ಅಭ್ಯರ್ಥಿಗಳು ತಮ್ಮ ಮನವಿಗಳಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಚೀಫ್ ಆಡಿಟರ್ ಆಫ್ ಕೋಆಪರೇಟಿವ್ ಆಡಿಟ್ ಗ್ರೂಪ್ ಬಿ ಪ್ರೊಬೇಷನರಿ ಹುದ್ದೆಗೆ ಕರ್ತವ್ಯ ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ಹೆಚ್ಚುವರಿ ಕಾಲಾವಕಾಶ ಕೋರಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇನ್ನು ಮುಂದೆ ಕಾಲಾವಕಾಶವನ್ನು ನೀಡಲಾಗುವುದಿಲ್ಲವೆಂಬ ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸಾಮಾನ್ಯ ನೇಮಕಾತಿ ನಿಯಮ 76 ನಿಯಮ 18(2) ಅನ್ವಯ ಹಾಗೂ ಕರ್ನಾಟಕ ನೌಕರಿ ಜ್ಯೇಷ್ಠತಾ ನಿಯಮ 5(2) ಅನ್ವಯ ಉಲ್ಲೇಖದನ್ವಯ ಅಭ್ಯರ್ಥಿ ಜ್ಯೇಷ್ಠತೆಯನ್ನು ನಿಗದಿಪಡಿಸಿ ಈ ಪತ್ರ the moment it says that you are
Not only you will lose post. The government spends so much. Third person would have been appointed. Therefore, the second list, the remainder of the list starts operating. Wait, is now. Rule 2 refers to 18 months. It does not conspicuously relate to 18. So this conspicuous on mentioning of 18(2) is significant. What is your submission?
My lord, my first submission is, your lordship, this is challenged after 24 years, your lordship. After 2 seniority lists of assistant directors and deputy directors have been published, no objection was filed. Now, after 24 years, the government want to tinker with this, your lordship. That is one my submission, your lordship. Second, your lordship, if my learned friend interpretation is accepted, 18(2) becomes inherent. Harmonious construction requires 18(1) is to be read along with 18(2). Therefore, section 5, rule 5 will not be come in the way of the cut.
Repeat, please repeat.
Your lordship will kindly see, harmonious construction is to be made.
Where is the conflict?
The conflict is this, they say, your lordship. Section rule 5, when it refers only to 18(1),
Correct.
then your lordship 18(2) would become independent unless it is read as the part of 18(1).
No, it will not become redundant.
Your lordship will kindly say.
How?
Otherwise, what is the purpose of 18(2)?
Purpose of 18(2) is that you should not go home without an appointment.
Yes. Then your lordship will kindly see, is there a difference between the wording of 18(1) and 18(2)?
Naturally.
Illa, there is no difference.
18(2)
Yes, I
is
understand.
extended period to you on your request.
Yes.
Nothing more than that.
But your lordship will kindly see, in a service jurisprudence, ranking is always considered for the basis for a seniority. It is not the date of a person reporting it.
No, then 5(2) will die.
Your lordship will kindly, I am placing a decision of the Supreme Court. Your lordship will kindly see, Supreme Court lays down, and it is a well-known thing, your lordship. Ranking is to be fixed on the basis of the merit, not on the day which when he reports it, your lordship. That will not be there.
No, it's not that well known. Yeah.
It is a short decision made. Read this, Lord.
Which rule is considered?
Yes.
Which is the rule which it considers?
This appeal arises from the judgment of the High Court of Orissa in so and so case. The respondent and others were selected by direct recruitment as managers of a rural bank. His rank was number 9 in the merit list. He was directed to be given a seniority on the basis of the date of his reporting to duty. it is reported that the first respondent is dead. The only question in this case is that what shall be the ranking among the direct recruitee? Is it the date on which they joined the duty or according to the ranking given by the selection board? On a comparative evaluation of the respective merits of the candidate for direct recruitment, the board had prepared the merit list on the basis of the ranking secured at the time of the selection. It is settled out that if more than one are selected, the seniority as per ranking of the direct recruit is subject to the adjustment of the candidate selected on applying the rule of reservation and the roster. By mere 40 chance of reporting to duty earlier would not alter the ranking given by the selection board and the arranged one as per the proposed roster. The High Court is therefore wholly wrong in its conclusion that the seniority shall be determined on the basis of the joining reports given by the candidate selected by the appointment by direct recruitment and the length of service on its basis. The view therefore is wrong. However,
Which rule is quoted?
the rule
What is the principle emerging?
I
from this?
understand no rule is quoted, but
No, here are rules.
yes, Your Lordship. My submission to Your Lordship is 18.2 and 18.1. There are subject matter is one and the same. Under 18.1, I was called upon to report to the duty within a period of 15 days. 18.2 says if you cannot, you must seek for a permission and a permission is granted. When a permission is granted, Your Lordship, reporting the duty under 18.1 or under 18.2, there is no difference, Your Lordship.
Then the 15 rule 5.2
Yes, 5.2
would have mentioned the rule 2 also of 18.
Your Lordship will kindly say, if a legislature, this is a delegated legislation, this is not a legislature. In a delegated legislation, Your Lordship, for whatever the reason a particular rule is not comprehensively laid down, then Your Lordship has to appreciate harmonious construction of
The conflict anta.
the conflict is this, Your Lordship. As I made a submission, whether I report under 18 or 18.2, Your Lordship, my ranking is the same.
All right, leave that point. We have understood. Why, after how many years you wanted to do this?
24 years.
How?
24 years.
After 24 years.
After 24 years. 5.2 was not taken into account, my lord.
After, when Alexander had come here, it was not taken into account. Can you change the things now?
That's what we did, my lord.
That's what
Right.
you did. How are you going to justify? Rule is another part.
Yes.
How could you do it? After years, decades, is the question. Justice Ramajoyce writes, all disputes relating to seniority should be disposed of within a particular period. You can't 20 years, you cannot bring back the waters that have flowed under the bridges. What is the reason why you wanted to alter? Because they accepted, parties had accepted. All these 2 seniority lists have been published.
Yes, ma'am.
Why? What is the reason? Vyavara. What is the reason? Why you alter? Why you wanted to alter? The order. Where is that order? Show that order. The right wrong is another thing. But in seniority matters, delay and latches, Justice Ramajoyce and the latest that other, Samaraditya Pal. Samaraditya Pal, vide Kulashrestha, Ramajoyce, all their of the opinion, in the matters like seniority, the belated challenges, belated intervention should not be tolerated. Where is your order in the paper book?
Yeah, 15, sir. You understood what it was saying.
Which is the impugned order before the K? Page number?
Page number
50? Twelve, 10, 2022. Where is that order? Annexure ಏನು?
Page number 250.
208 to 234.
208.
Page number 250, my lord.
208 alva.
39 ತಾನೆ?
39, 20,
250, my lord. 1210 to
1210.
22.
250.
39.
250, my lord. ಈ ತಾತ್ಕಾಲಿಕ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಗೆ ಸಂಬಂಧಿಸಿದೆ.
ಎಷ್ಟು ಹೇಳ್ತೀರಾ ಪೇಜ್? 250.
First seniority list ಯಾವ ಪಬ್ಲಿಷ್ ಐತೆ ಯಾವ ಡೇಟಿಗೆ?
23/4/2001, my lord.
ಇಲ್ಲ ಇಲ್ಲ. Page 208 minutes is the orders impugned.
First seniority list dated
23/4/2001, my lord. 23/4/2001, my lord. Assistant directors, seniority list.
where
Another is the, my lord.
One second. Where were you? What was your ranking? What was the ranking of the clients of Mr. Abhishek? Give it.
Applicant ranking was 298, my lord.
Applicant is your client.
Yes, my lord.
Yes.
Another was 287. There are two applicants.
Two applicants. Ranking at ranking ಹೇಳಿ 287 and
298.
290. What was the ranking of your clients?
I just point out. Understood. Page number 188. ಇದೆ ತಾನೆ? Lords, 175 is Khan Parvez.
You are?
Lords, I am Ramegowda. I was at 179. As against Khan Parvez at 175.
In 23/4/2001 seniority list.
No, no, this is the seniority list of 2018.
It cannot, if you go to 2001 seniority list.
2001 seniority list is not a part of the record minutes. ಇದೆಯಾ? ಇದೇನಿದು? ಇದೆಯಲ್ಲ 2001. Notes, it is there. I'm sorry.
ಇರಲೇಬೇಕು.
It is there.
Next year, A4.
ಇದು 23/4/2001 annexure is
Notes, annexure A3, page 87. I'm sorry, annexure A4, page 88. Typed copy. Yes, annexure A4, page 88.
Second seniority list.
Second seniority list.
Like in the first seniority list, where your clients stand? Your clients are standing where?
200 and.
It must be below 287 and 298.
Yeah. ಎಲ್ಲಿದೆ 298.
It must be below. It cannot be above.
306 is Ramegowda.
306
Ramegowda, that's the first petitioner.
and
312 is Sridhar, the second petitioner.
312. Both must be below.
There is one Rangaswamy.
Second list is dated
But second list is dated
2000
18/12/2009.
9.
1812 2009. Annexure
Annexure A5 is the
A5.
yes.
Page
107.
Lots 23/4/2001 is Tatkalika Jeshtata Patti.
3/4/2001. When it was finalized?
Lots that is not finalized at all. Even at 18/12/2009 minutes, what is being referred to, it says.
Did you file objections to the Tatkalika Patti saying date ought to have been this and not ಅಂತ ಅನ್ಕೊಂಡು ಎಲ್ಲಾರ ಹೇಳಿದ್ರ? No.
No.
Two thousand eighteen,
Bring Rama Joyce.
2009 ಅಲ್ಲಿ
Bring Rama Joyce and Samaraditya Pal. ನೋಡಿ ತಕ್ಕೊಡಿ ಸೀನಿಯಾರಿಟಿ ಇಲ್ಲ ಅದೇ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ತಕ್ಕೊಡಿ. ಸೀನಿಯಾರಿಟಿ ಸಂಬಂಧಪಡುವಂತ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಅನ್ನ ಬಹಳ ಬಿಲೇಟೆಡ್ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡಬಾರದು ಅನ್ನೋ ಸೆಂಟೆನ್ಸ್ ಇದೆ ನೋಡಿ, ತೆಗಿ. ಇದರಲ್ಲಿ
3 to 4 years judgment ಇದೆ.
On seniority, Dr. Rama Joyce has treated it as a chapter.
But even 2008 is a tatkalika
All right, where did you object? Who objected?
The final list which is coming to exist.
That is the question is where you object.
It's the government after publishing the seniority list.
Why did you do that, brother? Government? Who is defending? Who say? Why 2 does not refer to 18.2?
Page 208.
18.1. Therefore, you should change anta yaar objection ಕೊಟ್ಟಿದ್ರು?
Lords, all the lists which are operated as seniority lists were
Provisional.
provisional.
Therefore, you were given an opportunity to file objection. Where did you file?
Now kindly have a look at page 208, Lords. This is the order of the government which is set aside by the SK80.
No, we are asking.
Lords, see, the order itself speaks, Lords, as to why they did it. Page 208.
208.
Yes. Vishaya.
208.
That is very important, Lords. ಸಹಕಾರ ಸಂಘಗಳ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ಇಲಾಖೆಯ ದಿನಾಂಕ 77ರಿಂದ 21ರವರೆಗಿನ ಅವಧಿಯ ಸಹಾಯಕ ನಿರ್ದೇಶಕರ ಮೂಲ ವೃಂದದ ತಾತ್ಕಾಲಿಕ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿ ಪ್ರಕಟಿಸುವ ಕುರಿತು.
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಬನ್ನಿ.
ನೆಕ್ಸ್ಟ್ ಸರ್ಕಾರಿ
ವೃಂದದ ಅಂತಿಮ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲಾಗಿರುತ್ತದೆ.
ಇದು ಮಾಡ್ತಿರೋದು ಇವಾಗ.
ಇದನ್ನು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿದೆ?
That of course I'll have to take instructions if there were.
Why did you do this?
Kindly see the 159 Miller, page number 159 Miller.
159.
Yes, Miller. ಅಧಿಸೂಚನೆ 27/11/2017 Miller, dated.
ಏನಿದು?
ಸಹಕಾರಿ ಸಂಘ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು ಅಂತಿಮ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ ಪ್ರಕಟಿಸಲಾಯಿತು. ಉಲ್ಲೇಖಿತ ಆದೇಶದಂತೆ ಸಿವಿಲ್ ಅಪೀಲ್ ಸಂಖ್ಯೆ 2368/2011 ಪ್ರಕರಣದಲ್ಲಿ ಗೌರವಾನ್ವಿತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ 9/2/2017 ತೀರ್ಪಿನನ್ವಯ ಸಹಕಾರ ಸಂಘಗಳ ಲೆಕ್ಕ ಪರಿಶೋಧಕರ ಉಪ ನಿರ್ದೇಶಕರ ವೃಂದ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಪರಿಷ್ಕೃತಗೊಳಿಸಿ ಪ್ರಕಟಿಸಬೇಕಾಗಿದ್ದು, ಅದರಂತೆ ದಿನಾಂಕ 77/2017 ಉಪನಿರ್ದೇಶಕರ ವೃಂದದ ಮೂಲ ವೃಂದದ ತಾತ್ಕಾಲಿಕ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಗಳನ್ನು ಸಿದ್ಧಪಡಿಸಿ ಈ ಅಧಿಸೂಚನೆಗೆ ಲಗತ್ತಿಸಿ ಅನುಬಂಧ 1 ಮತ್ತು 4ರಲ್ಲಿ ಪ್ರಕಟಿಸಲಾಗಿದೆ. ಈ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯಲ್ಲಿ ಅಧಿಕಾರಿಗಳ ಹೆಸರು, ಜನ್ಮ ದಿನಾಂಕ, ಸೇವೆಗೆ ಸೇರಿದ ದಿನಾಂಕ, ಶ್ರೇಣಿ ಪದೋನ್ನತಿ ಹೊಂದಿದ ದಿನಾಂಕ ಮತ್ತು ಮೀಸಲಾತಿ ಇವುಗಳನ್ನು ಬಿಟ್ಟು ಹೋಗಿದ್ದಲ್ಲಿ ಅಥವಾ ವ್ಯತ್ಯಾಸಗಳಾಗಿದ್ದಲ್ಲಿ ಸರಿಯಾದ ದಿನಾಂಕಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಸಮರ್ಥಿಸುವ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಈ ದಿನಾಂಕ ಪ್ರಕಟಿಸಿದ ದಿನಾಂಕದಿಂದ 15 ದಿನಗಳೊಳಗಾಗಿ ಸಹಕಾರ ಸಂಘ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು ನಿರ್ದೇಶಕರು ಬೆಂಗಳೂರು ಮುಖಾಂತರ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಬೇಸ್ಡ್ ಆನ್
ಯಾರು ಕೊಟ್ಟಿದ್ರು ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಆಗಿದೆ, ಚೇಂಜ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಯಾರು ಕೊಟ್ಟಿದ್ರು?
I'll secure my this. I'll secure instructions.
What secure? In your objection, you should have. This is
my objection. My
seniority.
Yes, my lord. My objection is
Where have you stated?
5-2. Based on 5-2, I have said objections, my lord. Rule 5-2.
ವ್ಯವಹಾರಕ್ಕಾಗಿರುತ್ತೆ. ನಾವು ಹಿಂಗೆ ಹೇಳ್ಬಾರ್ದು, ಬಟ್ ನಾವು ಹೇಳಲೇಬೇಕಾಗತ್ತೆ. ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್? ನಿಮ್ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಂಥ ಎಕ್ಸ್ ಅನ್ನೋ ಎಂಪ್ಲಾಯಿ ಈ ರೀತಿ ತೋರಿಸ್ಕೊಟ್ಟ ನಮ್ಗೆ, ಅವಾಗ ನಮ್ಗೆ ಬುದ್ಧಿ ಬಂತು, ನಾವು ಅದನ್ನ ಓದಿದ್ವಿ, ಅವಾಗ ನಾವು ಚೇಂಜ್ ಮಾಡಿದ್ವಿ. ಎಲ್ಲಿದೆ ಅದು? ನೀವು 20 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಎಂಪ್ಲಾಯೀಸ್ ಸ್ಟೇಟಸ್ ಎಲ್ಲ ಆಲ್ಟರ್ ಮಾಡಿದ್ರೆ ಒಟ್ಟು ತಿಳ್ಕೊಂಡ್ ಮೇಲೆ ಮಾಡಿಲ್ಲ, ಅವ್ರು ಇದ್ದಾಗ ಒಂದ್ ಮಾಡಿರಿ, ಹಂಗ ಯಾರ್ಯಾರು ಕೋರ್ಟಿಗೆ ಹೋಗಕ್ಕೆ ಬಂತು. Why did you do? You have power to do is one thing. Existence of power is one thing. Exercise of power is another.
Page number 8.
Reason for exercise.
Para number 8, my lord, in my statement of objections.
Page number
4 in my statement of objections, my lord. Separate ಆಗಿ ಫೈಲ್
ರನ್ನಿಂಗ್ ಪೇಜ್ ಹೇಳಿ.
ಸಪರೇಟ್ ಆಗಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಇದಕ್ಕ ಅಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲನು?
ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದೀವಿ.
ಅಲ್ಲಿ ರಿಪ್ಲೈ ಹಾಕಿದ್ವಾ?
Sorry, I don't have the
276
Para 8.
Para 8 ನಲ್ಲಿ ಏನಂತ ಹೇಳಿರಿ?
Yeah.
It is submitted, state government is under the obligation to prepare the seniority list to
Correct,
each
sir.
cadre every year. Due to administrative reason, publication of seniority list was delayed. Initially, 15 days time was given for appointing candidate to report for their respective post. Respondent 4, Parvez Khan made a request at the
ಮಾಡಿದ್ರೆ
first
extend ಮಾಡಿದ್ರೆ
respondent.
ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆ ಏನಿದೆ? Why you are doing
ಬೇರೆ.
this ಅಂತ ಹೇಳಿದೆ? Why are you raising the dead things? Why you want to dig the grave ಅಂತ ತೋರಿಸಿ? Unless you wanted to favor somebody, you could not have done it, and you would favor somebody not obviously for not free. It is on quid pro quo basis.
So there appears to be a whole series of proceedings for about 5 years, my lords.
We are asking simple question because it's a classic case that would
That
fit
I
into
will-
seniority chapter. Who objected to this premise that seniority list ನಾವು ತಯಾರು ಮಾಡುವಾಗ ಈ premise ಮೇಲೆ ಮಾಡಿದ್ದೇವೆ?
There
ಅದಕ್ಕೆ
should have been,
objection ಎಲ್ಲಿದೆ? ಯಾರಿಂದ?
there should have been, my lords. I'll get instructions in that
That's
regard.
how.
I understand. If there is any such, page 210, my lords, is where the issue is considered. Page
We
210.
agree with the reasoning of the tribunal and dismiss the petition. First, the vehement submission of learned senior advocate, Mr. Ravi Shankar, that Rule 18(1) stipulates the joining time, and Rule 18(2) of conduct, general recruitment rules gives a discretion to the government to extend that joining time on request. First, Rule 5(2) of seniority rules refers to Rule 1 of 18(1), and obviously 18(2) is not mentioned. And therefore, the seniority should be prepared, list should be prepared on the basis of what happens under Rule 18(1). 18(1). First, he also further submits that in the absence of 18(2), the right to appointment in terms of 18(1) would have been forfeited, and that forfeiture is saved by 18(2), which has nothing to do with seniority. First, learned counsel professor opposes the construction placed by Mr. Ravi Shankar on Rule 5(2), which incidentally, apparently refers to Rule 18(1) and not 18(2), saying that there should be harmonious construction, more particularly because both these rules are delegated legislations. First, we have not been cited any authority in support of this contention that merely because the piece of norm has the character of delegated legislation, comma, that should be construed that way, as argued. First, no standard author like Jain and Jain, comma, IP Messi and SP Sathe, and also Wade and Forsyth, do not say that. Do not say that. First, we are saying this very consciously, having read those books. Next paragraph. The above being said, the question is not just an interpretation of a delegated legislation, but the consequences of altering arguably a wrong norm on which earlier seniority lists, comma, be they provisional or final, especially in the absence of the petitioners herein making any objection to the provisional list or the principle on which such lists were earlier prepared. First, the standard authors on service jurisprudence like Rama Joyce and Samaraditya Pal say that the long-standing ranking positions in the seniority list should not be disturbed on the ground that there is a legal lacuna in their preparation. Since they will have far-reaching consequences, more particularly in securing candidature for promotion or the like. First, Ramajay says like this, paragraph. Samaraditya Pal says like this. Therefore, we need not go for the right interpretation of 18(1) and 2 of the general recruitment rules and also rule 5(2) of seniority rules, the delay and latches being enormously great. First off, the idea of delay and latches would militate against the government also doing quasi-judicial functions like preparation and finalization of seniority list. First off. Next part, in the above circumstances, it will not be sufficient to show that the impugned order of the tribunal is wrong, legally speaking, what is required to be shown is that it is unsustainable also. First, that having not been shown, we decline interference.
Can I just make one request?
Yes.
Not for anything. Not that question may be kept open to be considered in any other case because this is having some consequence. There are so many other departments where this issue is still pending.
The question of law as to fixation of seniority under Rule 5(2), keeping in view 5(2) of seniority rules, keeping in view 18(2) of the general recruitment rules, which does not figure in Rule 5(2), will be decided, will be considered in an appropriate case. Okay. We are coming back in minutes.
Judgment ಸಿಕ್ತು ಬೇಕಾ? Judgment but judgment ಸಿಕ್ತು.
ಕೊಟ್ಬಿಡಿ ಅದು book.
Judgment ಇದೆ.
ಇದು ಇಲ್ಲ, ಯಾರು ಇಲ್ಲ.
Volume 1 is 55. ಸಿಕ್ತು
26 ಅಲ್ಲಿ 26 ಅಲ್ಲಿ ನೀವಿದ್ದೀರಾ ಸರ್?
CRPF ನಾವಿರೋದು
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ? ಸಿಕ್ಕಿಲ್ಲ ಅದಕ್ಕೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ.
ಕೊಡ್ತೀನಿ. Vincent.
All the
ನಾನು ಕರೆಯಲ್ಲ, ಅವ್ರು ಕರೀತಾರೆ.
Page 1.
ರಿಪೋರ್ಟ್ ಹಾಕ್ತಿದ್ದೀರಲ್ವಾ?
Page 1.
ಬರ್ತಾನೆ ಇರುತ್ತೆ. ಅವ್ರ ಕೈಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪ್ರಸನ್ನ ನಾನಲ್ಲ.
ಬೇರೆ ಎಲ್ಲಿರಲ್ಲ.
Good. Now the list. File ಹಾಕಿ ಕಟ್ ಮಾಡ್ಕೊಳ್ಳೋದನ್ನ ಇದು ಕೊಡಿ ನನ್ನ ಕಳ್ಸು. Yes. ಲಕ್ಷ್ಮೀನಾರಾಯಣ. Yes.
During the pendency of the petition, this court directed us to restore my seniority from the post of executive engineer to the assistant engineer. Earlier reversion has taken place. Now it has been restored to the post of assistant executive engineer. I was promoted, my lord, with effect from 17/6/2001.
What is the dispute about?
My lord, the dispute is that my promotion, my seniority, my lord, in the combined seniority list of assistant executive engineer was annulled by the AAT on the ground. Within a time, I did not opt for information of a new department. But this is a case where from PWD, a new rural irrigation, drinking water and sanitation department has been established in 2020. Option were belatedly exercised by me. That was condoned by the government under Rule 16 of the General Recruitment Code. And that was passed by my learned friend Bhajantri's clients. Ultimately, my lords, the tribunal held that my grading in the seniority, ranking in the seniority has been set aside. Now, my lord, there is a detailed order on 9/5/2024. If your lordship kindly see, but even if I
Order sheet.
Lord, suitability is different from seniority. Even if I become a junior most in the new department, there are only 33 posts of executive engineer. I have been already promoted to the post of assistant executive engineer, put in 3 years of service. Earlier 5 years, 2024 amendment says 3 years. I satisfy my lord 3 years of experience as AEE. My case has to be considered for executive engineer. That is the direction issued on 9/8/2024. Last direction.
This is interim order.
That is an interim order.
Now,
Now, my
ready
lord,
for hearing?
pardon, my lord.
Are you ready for hearing?
Yes, my lord. But I just prepared a chart.
Yes. 16/8/2007. Entry. ಈ ಚಾರ್ಟ ನೀವು ಕೊಟ್ಟಿದ್ದು.
Yes, yes.
Yes. ಎರಡು ರಿಟ್ ಪಿಟಿಷನ್ ಇಬ್ಬರಿದಾರನು.
Lord, I'll just give only two. One writ petition where I have been reverted from the post of AE to executive engineer on 24
to executive engineer.
AEE.
AEE to executive.
Sorry,
it has to be
assistant engineer.
Assistant engineer.
Has been challenged by me. If your lordship kindly take the date of joining is 7/2007. Then, my lord, 2009, I was promoted to the assistant engineer. 13/5/2020, rural drinking water and sanitation department. Then, my lord, as per the promotion order dated 3/1/2024, with effect from 17/6/2021, the petitioner would be completing 3 years as on 16/6/2024. Then, my lord, 15/3/2024, Rural Drinking Water and Sanitation Department amended its C&R regulation following eligibility. Earlier 5 years, my lord, it has been reduced to 3 years. So far as the executive engineers are concerned, there are only 33 posts. The government servant would serve for 3 years as an executive. That is the eligibility. Then 19/4/2024, after the tribunal order, The state government passed an order fixing the ranking in the seniority list as AE 28 instead of 70. 17A was set aside, my lord. Then 24 for the list published for the purpose of DPC showing the only 31 AE are working. At that time, out of the 3 of the AE has retired and 1 is the said AE is dead, and leaving only 27 persons is working as executive engineer. 6 more posts are left to be filled. As per the amended C&R rule, the petitioner is eligible to be promoted to the post of executive engineer, and she has completed 3 years of service as AE from 17/6/2021. Now the short question, blood, is this. I have been promoted as a AE with 3 years. There are only 33 posts of executive engineer. Only 31 people have been opted in the Department of Rural Drinking Water and Sanitation. Even if I go, milord, in the bottom of the seniority list, based on my suitability, I am entitled to be promoted. Milord, the tribunal said, since I did not opt for option within the time, I'll become a fresh recruit in the new department. That is totally wrong, milord. You lost me kindly. I'll read only 5 lines of the Supreme Court judgment. There is a distinction between the seniority and the suitability. Even if I opt for transfer on my own volition, my eligibility for further promotion about my previous service will not be wiped out. I will just read only 3 lines.
Though your seniority is altered,
Yes.
you will take the ranking at the below.
Yes. I'll just read only, 2000.
Judgment is Dr. Renuka Prasad versus State of Karnataka, Justice Dattu Sahibardu.
But actually, the history is from 1988, my lord. 2 contemporaneous
But I
judgments.
will just read only
which is
these
being
5
relied on
lines
by the.
so that let my learned friend argue.
ಏನು ಓದಾಗತ್ತಿಲ್ಲ, we know that.
Yes.
ಬೇರೆ ಹೇಳಿ. You need not read. What is known to the court, you may assume that court knows also.
No, no.
Yes.
The latest. That's it.
But you did not opt for joining that
In
department.
time.
In time.
There was a belated on 12/1/2020. That was condoned by the government. That was challenged by Mr. Bhajantri client. And the tribunal set aside it.
Because the
Even
donation
assuming-
would affect his ranking.
Yes. Even assuming.
Whether your client is ready to take his position below Bhajantri,
Yes.
he will take.
Yes.
ಮುಂದೇನಿದೆ ಮುಂದಿನ next ಏನಿರ್ತದೆ ಹಾಕೊಳ್ತದೆ.
Promotion from AW cadre to executive engineer.
ಅದೇ ಒಂದು from the pool ಆಗ್ತದೆ.
On the basis of the seniority, on the basis of the seniority in AW cadre. Because she will be placed below me.
She will be placed below you.
Yes.
She is agreeable.
Yes.
And posts are there, vacancies are there.
Let them.
ಯಾರು ಮಾಡ್ಕೊತಾರೆ.
Please.
Then what is your objection?
My lord, based on that, my lord, based on the fact that even if she is placed below the
Still she will be in the pool.
because she has completed the qualifying years of service in the cadre of AE, my lord, assistant engineer, she has been promoted during the pendency of this case to the cadre of AWE with effect from
No, anyway, all these things,
in 2024. my lord.
all these things will pale into insignificance because parties are agreeable that we will be in the same pool. Anta what Lakshmi Narayana says is very sensible advocacy.
Now what she is seeking is further promotion
ಯಾವುದು?
from the cadre of AWE to EE, for which
ಕೇಸ್ ಹಾಕಿದ್ಯಾರು ಅವರು? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದವ್ರು?
ಇಬ್ರು ಹಾಕಿದ್ದಾರೆ sir. May I just
ನೀವು ಹಾಕಿದ್ರಿ?
ಇಬ್ರು
ನಾನು ಇಲ್ಲ ಹಾಕಿದ್ದೇನೆ.
ಹಾಕೊಳ್ಳಿ.
There is already an order on 9/8/2024.
That's only
My
interim order.
further claim to the executive. should
That's
be
an interim order. That does not alter your rights, substantive rights. ಅದರಲ್ಲಿ ನೀವು, if you are ready to take, as you rightly said now, that you will take the ranking below Mr. Bhajantri's clients.
Correct.
All will be in the pool and all will be considered in accordance with law. Brother, what is your objection from the state?
But we had no objection insofar as promotion to AWE is concerned. So we have given her promotion.
We will only decide now.
Please.
The ranking ಏನಿದೆ, since their ranking was affected, that his ranking given to him would affect their ranking.
Please.
Now they are settling the list, saying that whatever be, whether government condoned it, what reason, we do not know. We will not assume that everything is bad. So government condoned and took him to that department. Is it not? And she becomes the part of the cadre.
Please.
So in the seniority list, she will be assigned ranking below Bhajantri's clients.
Please.
If there-
ಬೇರೆ ಯಾರು ಇದಾರನೋ
My lord, in
ಉಪ
fact,
ಮತ್ತು ಅವ್ರ ನಡುವೆ
No, if
Yes,
there are
there are-
vacancy, my lord, my
there are-
case has to be considered.
ಅವ್ರು ಇದಾರ.
ಇದಾರೆ.
ಎಲ್ಲಾರ್ಗೂ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ 31 ಜನಕ್ಕೆ, ನನ್ನೊಬ್ಬನ್ ಬಿಟ್ಟು, ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಪೆಂಡೆನ್ಸಿ ಆದ ಲಿಟಿಗೇಷನ್.
The next promotion is seniority come merit, merit come seniority now.
My lord,
seniority
seniority.
merit.
Seniority come merit. Still vacancies are there ಅಂತ.
Yes, my lord.
ಮತ್ತೆ ಅಷ್ಟು ಹೇಳಿ ಮುಗಿಸ್ಬೋಣಂತೆ.
Yes.
Page 112
Huh.
in the objections filed by me is the seniority list I have produced.
Why, what objection? He is saying that he will take the seniority below your client.
Yes, yes, but below me there are several others.
ಅವ್ರು ಬಂದಾಗ ನೋಡೋಣ.
Please.
ನಿಮ್ಮಿಬ್ಬರ ನಡುವೆ ಬೇರೆಯವರು ಇದಾರ?
Yes. That
But
is- that
even
is why
assuming
page
that
112.
I'll go to the bottom of the list, my lord.
ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ರೆ
No, bottom of the list.
She is placed at bottom of list, we have no.
No, since still.
When you gained entry to which post?
Yeah,
My lord, AE
list ನಲ್ಲಿ ಬರ್ಬೇಕಾಗ್ತದೆ.
AE list ಅಲ್ಲಿ ಬಾಟಮ್ ಹೋದ್ರುನು ನೆಕ್ಸ್ಟ್ ಪ್ರಮೋಷನ್
ನೆಕ್ಸ್ಟ್
ಎಕ್ಸಿಕ್ಯೂಟಿವ್
ಏನೇನ್ ಆಗ್ತದೆ ಅದು ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಅಲ್ಲ, ಅದು they will have to consider.
They have to consider that and this.
That's all, my lord.
ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು sir.
ಮಾಡ್ಬೋದು.
I only want to clarify what is now being sought is a further promotion from AEE to EE.
ಈ
Which is not,
exercise ಮಾಡಿದ್ರೆ
which is not within the scope of the prayer, my lord. All they have challenged is the initial order of absorption. My lord, once the petitioner gives up the claim for seniority over the clients
These
of
people.
Shri Bhajanti,
And not only over them, in between also with the.
if she is agreeable to being placed below in the list, below
number one.
everybody who was there on the date of her absorption into the new department, then, my lord, the writ petition at the first 7477 becomes
It
infractuous.
becomes infractuous.
Insofar as the second writ petition, the other writ petition is concerned, the prayer is actually for seniority. Because as per,
ಈಗ ಅದನ್ನ ಇದನ್ನ ಬಿಟ್ಕೊಟ್ಮೇಲೆ
ಹಾ.
ನೀವು have to rework out entire exercise. ಅದನ್ನ ಬಿಟ್ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಅವ್ರನ್ನ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ. Because Supreme Court said,
please,
one person coming to the bottom of the seniority list is one thing.
please.
His eligibility to have his case considered for promotion is another.
Correct.
That has to happen ಅಂತ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಿಕೊಟ್ರ ಆ ಪ್ರಕಾರ. ನೀವು ಒಂದು ಮೆಮೊ ಹಾಕಿ
Please.
ಬರ್ಕೊಡಿ. ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಟ್ಕೊಳ್ಳ. ಮೆಮೊ ಹಾಕಿ ನೀವು ನಿಮ್ಮ ಮೆಮೊಗೆ ಸೈನ್ ಮಾಡ್ಬೋದು ಮೋಸ್ಟ್ಲಿ, ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಏನು ಕಳ್ಕೊಳೋದೇನಿಲ್ಲ.
yes.
And others who are in between, the sandwich people ಏನಿದ್ದಾರೆ, they are also protected because he goes to the rock bottom.
Bottom of the list.
ಹೌದು.
Yes.
ಮುಂದಿನ ಎಕ್ಸರ್ಸೈಸ್ ಏನಿದೆ ಅಷ್ಟು ಮಾಡಿ.
Not why I made a statement.
No, this is a great advocacy. I understand, because otherwise you had some risk.
33 people executive engineers have been sanctioned, only 31 are available.
Working.
Even if I go to the bottom of the list.
Still you will be entitled to
Yes, ma'am.
consider your case for promotion. That happens.
So the petitioner was not willing to accept. I persuaded her to accept it.
Therefore you are called counsel. You are not just advocate. Counsel means ವಾದನೂ ಮಾಡಬೇಕು, ಅವ್ರಿಗೆ ಬುದ್ಧಿವಾದನೂ ಹೇಳ್ಬೇಕು. ನಮ್ಮ ಮುಂದೆ ವಾದ, ಅವರಿಗೆ ಬುದ್ಧಿವಾದ.
ಇಲ್ಲ, ಇನ್ನೊಂದು 50 ಜನ ಇದ್ದಿದ್ರೆ
You would not have got anything.
No, I would have argued that the government has got power under general recruitment. That may not arise.
But by and large, Renuka Prasad, ILR 2000 perhaps, Karnataka. That Dr. Renuka Prasad was state, by and large, this issue is covered. Justice, Honorable Justice Dattu's judgment. Pass on.
In fact, the main matter itself can be disposed of.
Huh.
This is a case where, my lord,
person, my lord, staying in my village out of animosity, my lord, initiates proceedings before the land grabbing court.
My lord, kindly pass over in this matter. My lord.
ಪಾಸ್ ಓವರ್
Pass over.
ಪಾಸ್ ಓವರ್ ಬೇಕಂತ
Very
ಅಥವಾ ಒಂದು ಬೇರೆ ಒಂದು ಡೇಟಿಗೆ ಹಾಕೋಣ
ಆಗ್ಬೋದು. ಒಂದು
ಆಗ್ಬೋದು,
date fix
ಆಗ್ಬೋದಾ?
ಮಾಡಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್.
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಒಂದು ಡೇಟ್
ಒಂದು date ಕೊಡ್ಬೋದು.
entry mod to continue. Call week after next. Next week on request.
26th. Grateful.
ಏನು ಎಂಟ್ರಿ ಮಾಡಿದ್ದೆ ಡೇಟ್ ಎಲ್ಲ ಕೊಡೋದು ಬೇಡ. ಕಾಲ್ ಆಫ್ಟರ್ ಎಸ್. ನೆಕ್ಸ್ಟ್.
My lord, I request a pass over. I have engaged a senior counsel.
This, my lords,
This,
I am filing
my lord-
my statement of objections to the vacating stay application, my lords, and my rejoinder to the statement of objections, my lords. I'll file in the registry, my lords. My lords, may I have it tomorrow, please? My lords.
My lord, senior counsel was not available tomorrow and day after, so.
ಬೇರೆ ಡೇಟ್ ನಾಳೆ ತೊಗೊಳಲ್ಲ ನಾನು.
ಅದೇ
Tell another
ಅವ್ರ ಹತ್ರ ಒಂದ್ಸರಿ his availability I don't know, so.
Thursday
pass over.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
My lord, in this, my lord, in this,
Matter, my lord,
my lord, in this age is appearing, my lord, he is not keeping well, my lord. Kindly have tomorrow, my lord.
Tomorrow.
Lord,
Tomorrow. Next.
Assistant, my lord, they have been repatriated, though there is a specific instruction, my lord, that the third respondent continue them till at least the regular recruitment is done. Identical matters, your lordship have been pleased to grant an interim order, my lord.
My lordship has granted an interim order.
Page 67, Annexure C.
Issue emergent notice. Learned AGA is requested to accept notice for all respondents.
Yes.
Alva?
Yes.
All respondents. Full stop. We are told at the bar that in identical matters, this court has already granted some interim protection, and therefore the same should be extended to the petitioners in this case as well. Full stop. A division bench of this court in a coordinate bench of this court in so and so. ಅಲ್ಲಿ ಇವ್ರನ್ನ ಕೇಳ್ಕೋಬೇಕು ನಮ್ಮ PSN has observed as under. Next. In view of the above interim order, as in
WP 6532 of 25, page 67, Annexure C, my lord.
ನೋಡಮ್ಮ page 67. An exercise as in science. Call this matter along with the WP 6532 of 2025.
Please.
After 4 weeks. ಅದನ್ನ ಪ್ರಿಂಟ್ ಮಾಡಿಸು. Okay. Next.
Same same one.
ಯಾವ್ದು?
Identical.
18.
Yes, 18 also.
17, 18, same order, call along with. Yes.
There is one respondent number 9, independent.
Private
Private
party.
party.
Issue emergent notice to 9th respondent.
Please.
In ಉಳಿದವರಿಗೆಲ್ಲ state. Yes. Yes, sir.
Petitioner is hearing challenging the order passed by the Honorable KAT, my lord.
Yes.
My lord, petitioner is a engineer in the respondent department, my lord. As a junior engineer, he has appointed. Subsequently, he has promoted, my lord.
Yes.
Because of his family issue, he was divested, my lord. That is only a reason. He was upset about the life, and he has given the representation for resignation, my lord. That resignation has accepted after the lapse of 18 months, my lord. In the meantime, the relatives and friends advised him to take back his resignation letter, give the representation to the department, my lord.
When did you give just give the foundational fact?
Yes, please, my lord. Please.
When you applied for resignation, when you sought for resignation?
Yes, on 16/7/2009.
When was it accepted?
Then we filed another withdrawal of the resignation on 7/4/2011, my lord.
One second. When was it accepted? Resignation was accepted on which date?
On 23/2/2011, my lord.
23 to 2011. ನೀವು ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟ ಮೇಲೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರ ಅಕ್ಸೆಪ್ಟ್ ಆಗೋವರೆಗೆ ಅಥವಾ ಹೋಗ್ಬಿಟ್ರ ಕೊಟ್ಟು?
ಸ್ವಾಮಿ ನಾನು ರಜಾ ಹಾಕಿದ್ದೆ, ನನಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಸ್ವಾಮಿ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಐ ರಿಕ್ವೆಸ್ಟೆಡ್, ನಾನು ರಜಾ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀನಿ, ನನ್ನ ಎಂಟರ್ಟೈನ್ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇದನ್ನ ಕೊಡಿ. ನೀವು ಯು ಅಪ್ಲೈಡ್ ಫಾರ್ ವಿಡ್ರಾವಲ್ ವೆನ್?
ಎಸ್. ಎಸ್.
7
Sorry, my
2000.
13 level 2010 is what?
Huh?
13 level 12 2010. Annexures of 2 days like
13, 12.
12 2010.
That is before it was accepted.
Lordship, from the date of his resignation, he did not appear.
He
appear
went
the
away.
duty. He went away. After accept of the resignation, Lordship, he has filed after 5 years of the,
No,
from
my
the date of the acceptance of the resignation, he had approached the KIT Lordship. challenge.
No, my lord. No, my lord. Only 2
I am
months
doubting.
delay, my lord. My lord.
Law on the point will tell you. The consistent view of the apex court from the days of Indira Nehru Gandhi versus Rajanarayan is an employee ordinarily has a right to resign
Yes.
from the post.
Please.
And Puttaswamy to reiterate it.
Yes.
But once he makes an application, before it is accepted or deemed to have been accepted,
Yes.
he can seek its withdrawal.
Yes, my lord.
This is subject to the condition that you will continue to work even after submitting the resignation letter. If you apply like the only judges can do that way. A judge can just send a letter. If I send letter resigning, it does not need acceptance at all. My sending letter itself is a resignation.
Yes.
But in your case,
Yes.
ordinarily, resignation needs to be treated, accepted or rejected, as the case may be. Some courts have said communication of acceptance is necessary. Others have said may not be necessary. But any time before it is accepted, you could have withdrawn your resignation, provided that after the shooting that resignation letter,
Yes.
you were still continuing in the employment.
Here, what
If you have already ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟೇನೆ ಮುಗೀತದು ಅನ್ಕೊಂಡು ಹೋಗಿದ್ರೆ
ಹ್ಮ್.
ಅವ್ರು ಹಂಗೆ ಹೋಗ್ಬಿಡೋದೆ, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇದು ಕಾಂಟ್ರರಿ ಇರುವಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ, ರೂಲಿಂಗ್ ಇದ್ರೆ ಕೊಡಿ. Because we may be wrong also, we do not know. ILR 1997 Karnataka. Bank of India versus so and so. 96, 97. When an employee can withdraw the resignation. Bank of India versus so and so. Name I do not remember.
I relied upon 1987 Supreme Court case.
87 is referred in that judgment.
Yes.
87 says
Yes.
life is a game. So many things happen.
Yes.
Sometimes some concession has to be given so that he can change his mind and come back to the employment of the whole body.
Yes.
That is treated in 1997 by Justice Thakur's judgment. Justice Thakur on voluntary, Thakur on resignation. The Bank of India versus Science. So Bank of Baroda versus Science.
Also, my lord, annexure N, my lord, page number 104, my lord.
Now, in those cases, they continued even after applying for a resignation till it is accepted. But in your case, you went away.
My
Only
lord,
constitutional authorities can resign that way, not your client. We can resign that way. If I send a letter, over, resignation comes into effect.
even I went to work, my lord.
When
They are
did you
not-
work? When did you work?
I requested, they are not allowed inside the, my lord. In this regard, I made the I made the submission to the Minister of,
When did you,
yes,
when did you send?
yes, I made, yes.
ನೀವು ರೆಸಿಗ್ನೇಷನ್ 16/7/2009 ಕೊಟ್ಟ ಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ಯಾವಾಗ ಹೋದ್ರಿ ಆಫೀಸಿಗೆ? ಇದಾದ್ಮೇಲೆ
ಸಬ್ಸಿಕ್ವೆಂಟ್ ನಾನು 2-3 ತಿಂಗಳು ಹೋಗಿ,
ಎಷ್ಟು ತಿಂಗಳು ಹೋಗಿ ತೋರಿಸಿ, ಯಾವತ್ತು ಹೋದ್ರಿ ನೀವು? ಅದು ಮಧುಮಿತಾ ಬಾಗ್ಚಿ had argued that matter. Can anybody trace out that judgment from the bar?
this one,
Professor Nagaraja, which is 90s Bank of Baroda? Huh? Even my memory is also diminished. It has diminished. Hey. There is a shloka in Bhagavad Gita. Smriti Bhramshat Buddhinasho Buddhinashat Pranashyati. If our memory goes down, the intellectual sharpness declines. And that is a prelude for our fall, anta heltan Bhagavanta. Anyway, everybody's memory. Therefore, greats write before the memory fades, etc. All from memory. This thing. No, it's not.
Whenever
you can withdraw any time before it is accepted.
circumstances must be made out.
That's what. That's what. Correct. That's how.
Made out.
No, Justice Thakur, Honorable Justice Thakur, as his lordship then was, has treated that subject very beautifully.
Well, merely because we permitted to, you can't make an application withdraw that. A change of circumstances is made out.
In the Indira Nehru Gandhi, identical question arose. There was one Yashpal Kapoor. The allegation by Radnarayan was, Srimati Indira Gandhi had made use of state machinery for electoral process. What was he? Mr. Yashpal Kapoor, who was an employee in the department, was serving Indira Gandhi at that time. This vitiates the election process. They, Justice Khanna treated that subject. There is an employee can withdraw resignation at any time. Government has power to prescribe with effect from which date the resignation would take effect. In the meanwhile, government amended the rule with retrospective effect, saying that Yashpal Kapoor's resignation is deemed to have been accepted before the election date. So it's a beautiful discussion. It's one of the best judgments on that from many angles, which at a turning point of history, 1975 judgment, Supreme Court. ಸಿಗ್ಲಿಲ್ವಾ? ಸಿಗ್ತಾ?
1996 volume Bank of India versus Presiding Officer Central Government.
Correct.
6th February 1996 judgment was passed.
Padi. Can you take out that copy?
Yes.
Just read on paragraph where it refers to 86 Supreme Court also, I believe.
Yes, sir.
Justice Thakur's judgment.
Sethi and R.L. Anand.
Sethi and Agarwal.
R.L. Anand.
Read that. Twenty-six, 97th again, Justice Thakur judgment sigda. One of the best judgments. Kindly be seated, please. Mr. Nagarajan, kindly be seated. Be seated. ನನ್ನ notes ಇದೆಯಾ? Justice Ramajoy's book ಮೇಲೆ which notes I have made. Then ಅಲ್ಲೇನ್ರಿ ಇದು? First edition. ILR 95, 96 or 97 it is. Justice Thakur. This covered by judgment, brother. It's covered by judgment. Because you went away. In all those cases, they continued in service. Therefore, there is one view saying that you could have been treated as having abandoned the service is one thing. Or you could have been dismissed because you have abandoned without permission is another. But to establish your right, you should have been in the office saying, I had applied, but I have withdrawn before its acceptance. That would have enured to your benefit. Any correct is
Annexure F, my lord. I have given the
that
representation.
makes no sense because that was, you are not telling us 16/7/2009 ಆದ್ಮೇಲೆ first time when you went to office. Answer that question. That will decide the issue.
Within 20 to 25 days, ನಾನು hospital admit ಆಗಿದೆ.
ನಿಮ್ ರೆಸಿಗ್ನೇಷನ್ ಲೆಟರ್ ನಲ್ಲಿ ಏನಂತ ಕೊಟ್ಟಿರಿ? ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗಕ್ ಹೊರಟೀನಿ, ರಿಸೈನ್ ಮಾಡ್ಕೊಂಡು ಹೊರಟೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿಲ್ಲ. ಇಟ್ಸ್ ನಾಟ್ ದೇರ್. Petitioner is grieving before the writ court against state administrative tribunal's order dated 18/12/2020, whereby his application number 5235 of 2017 has been negatived. First up, please be seated. He was complaining before the tribunal that the respondents have grossly erred in accepting his resignation letter dated 16/7/2009 on 23/2/2011, when in the interregnum, while letter dated 13/12/2010, he had sought for withdrawal of the application. First, next paragraph. Learned counsel for the petitioner vehemently argues that law relating to resignation is well settled by now. Semicolon. Ordinarily, every employee will have a right to apply for resignation unless otherwise provided by the service rules. Semicolon. The service rules regulate making and acceptance of resignation. Semicolon. The apex court in a catena of decisions has observed that an employee can withdraw the resignation letter at any time before it is accepted, unless the rules otherwise provide for. First up, he further argues that the resignation letter having been withdrawn, there was nothing which the government could accept on 23 February 2011, and therefore the impugned order of the tribunal as also government's acceptance of resignation are liable to be voided. First, next paragraph. Learned AGA appearing for the official respondents vehemently oppose the petition, making submission in justification of the tribunal's order and the order of the government accepting the resignation. First off, he submits that ordinarily an employee is entitled to withdraw the request for resignation at any time before it is accepted, is true. However, if the employee, after submitting the resignation letter, goes away from the employment once for all, such an ordinary norm would not be invocable because of the conduct that animates the request for resignation. First, he also adds that one fine day, months thereafter, an employee cannot come back saying that he wants to withdraw the resignation. First, next, having heard the next paragraph, having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the tribunal. Right. First, law relating to resignation.
285, alternate the condition subject to which these two cases are. Then what is, please,
But in fact, Rama just treats this.
that the condition subject to which he, within the, before the date, he can withdraw.
Correct. Notice of rule of the appointing authority, provided the request for such withdrawal is made within the intended date of retirement.
And making changes.
And the government servant is in position to establish that there has been a material change in the circumstance.
My submission to your lordship is that if he should be continued in service, that is not found in the rules. That means
No, we have held that way in one judgment.
Judgment be, then the rule, there is no such a condition.
Correct.
In the rule, there is no such.
No, otherwise, what happens is,
I understand.
government will be at the disadvantage of having
Making-
government cannot make appointment.
Either by-
And the post also cannot be kept to.
by promotion or by. a-
So many things will happen.
So many things. Correct.
Barclay.
Judgment. Judgment. Based on the judgment, my lord, this is Justice C.K. Thakkar and Justice B.N. Sri Krishna. In that, they have said the resignation can be withdrawn within the notice period.
Correct.
It's a Supreme Court judgment.
That
The
is what-
citation.
That is all.
2000.
Supreme-
The law relating to resignation can be summarized this way, colon. An employee can apply for resignation at any time unless the rules otherwise provide, semicolon. He can also withdraw the resignation request at any time before it is accepted unless the rules otherwise provide, and subject to the modalities.
Even it is accepted also before.
Even
written
then
that
he can
written-
withdraw on the
written
old
that
model,
date.
87 Supreme Court. Yeah. The apex court has held that even after acceptance, resignation may be permitted to be withdrawn subject to exceptions. Exceptions. First. Next paragraph. The above ordinary rule position would not come to the aid of the petitioner inasmuch as after submitting the resignation letter on 16/7/2009, he vanished away from the employment. First off, he made the application for withdrawal only on 13/12/2010, that is after more than a year, reckoned from the date of request. First off, in the meanwhile, the resignation was accepted on 23/2/2011. First off, this we would have faltered, had the petitioner continued in employment. First off, however, his conduct shows that very knowledgeably and intentionally he had resigned, and therefore he went away from the employment. First. Next paragraph. Absence of an employee from the seat or post in public employment would create lot many difficulties, needs no research. First. Next paragraph. In the above circumstances, petition is dismissed. ಇದೊಂದು ಕೊಟ್ ಮಾಡ್ಬೇಕಲ್ಲಿ 2005 8ACC 314. Thank you.
One lecture we am not. A joint director of the department to contest in the election somewhere before 2000, 2000 around. Of a department, I will never say government. He contested for the sake of contesting the election, he take voluntary retirement. Then the party concerned party did not give seat. The same he came with before the. Then only on this ground that petition was dismissed.
No, I only dismissed
Yes,
that.
yes.
He was from transport department.
Yes,
He was related to a minister.
yes, yes.
And he had, he contested election, lost the election and deposited.
Then
And came back saying that I want to rejoin
Yes.
the post. Nodi,
This is what many times it happens.
S.V. Narasimhan had argued that
Yes, yes.
matter before me.
Yes.
I remember.
Therefore, the change of circumstances is very much important.
Correct, you're right. Something like that. Yes.
Please note, the state and its authorities are before this honorable court in filing this writ petition
Yes.
against the order of the tribunal allowing the application filed by the respondent, my lord. He was subjected to disciplinary inquiry in connection with a trap case by the Lokayukta, where he was caught with the tainted money, my lord, for demanding a bribe of 50,000 rupees. Initially, it was 58,000. It was negotiated down to 50,000 rupees, and he was caught with the tainted money. The tribunal gives a finding based on the evidence of the complainant and the shadow witness, who have said that, in fact, the money was kept. He did not ask for the money. When he went to the washroom, it was kept in his bag.
But hangu ಮಾಡಿದಂತ cases ಇದೆ.
But ಏನಾಗುತ್ತೆ ಇಲ್ಲಿ, what the tribunal fails to notice, my lord, is that the money was actually recovered from the Almira. That is there in the inquiry report. May I take your lordships through the relevant passages, my lord?
ಅಲ್ಮಿರಾದಲ್ಲಿ ಯಾರು ಇಟ್ರು?
ಅವರೇ ಇಟ್ಟಿದ್ದಾರೆ.
ಅವರ ಪಿಂಕ್ ಟೆಸ್ಟ್ ಏನಾಯ್ತು?
It has been positive, my lord.
Positive?
Yes.
Issue ನೋಟಿಸ್ ಆಗ್ಬೇಕಾ?
ಆಗ್ಬೇಕು ಸ್ವಾಮಿ, ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೇಳಿರಿನ?
Entry order is sought for, my lord.
Is retired now.
Is retired, my lord.
Issue emergent notice.
Contempt proceedings have not yet been initiated as per my instructions, my lord. So,
And stay of impugned order.
grateful.
Please, your lordships, I appear for the petitioners in this matter.
Yeah.
My lords, in this petition, we are challenging the procedural arbitrariness in the PSI recruitment process only, my lords. Paper 1 is vitiated.
24th it is fixed before the tribunal. ಇಲ್ಲಿ ನಮ್ಮ
In the morning, the matters which were listed, my lord, at serial number 8.
Along with those matters.
We can, my lords, but with
Alternate AG is requested to accept notice for response. Private parties is there, no?
illa, my lord.
Illa.
No private party.
You gave that judgment 2005 Supreme Court?
Please, my lord, yes.
That's very good of you.
Thank you, my
Okay.
lords. With your
Copy
lordship's
code.
permission, may I make one more submission?
Yeah.
There's a urgent consideration needs to be given to one subsequent development, my lords. They have proceeded to issue appointment orders without even drawing the final select list, my lords, which goes against the rules.
Is it true?
Please see annexure F, my lords.
Anything may happen. In fact, during our childhood, when Alauddin's lamp was told to us, we were very, very mesmerized. Now we are more mesmerized by things that are happening. Alauddin is just nothing. He is really rendered juvenile.
Annexure F, my lords, in volume 2 of my petition, page 535, my lords.
In those matters ಏನಾಗಿದೆ? ಅಲ್ಲಿ entry order ಕೊಟ್ಟಿದ್ದಾರಾ?
Interim order is just that 3 vacancies should be kept open anta ide, my lords. At the time of the first hearing, they were
apprehensive that final select list would be drawn. To overcome that apprehension, they have directly issued appointment orders without even drawing the final select list, which is clearly forthcoming in Annexure F, my lords.
Why tribunal was not impressed by your argument?
I was not the counsel.
No, we are not on who counsel.
At that
The
time, this
party,
had not happened, my lords.
You are very great lawyer, we agree. But why the tribunal not impressed by the argument that's stated in the order?
Please, Annexure F, my lords. Annexure F, Volume 2 of the petition.
Annexure F.
Annexure F.
Where have you taken up that contention in the application?
This is a subsequent development, my lords. At the
Now,
time, after the applications, even when the tribunal was in season of the matter, they have issued such an order, my lords.
even
with
then
scant
tribunal
regard.
denied relief to you.
They had reserved it for orders, and even the other petitions are pending before this honorable court. Yet they have completely bypassed the step of drawing a final select list and issued appointment orders.
Just ascertain whether
6th February 25 ಗೆ ಆದೇಶ ಆಗಿರ್ತಕ್ಕಂಥ
ಏನು ಅಪಾಯಿಂಟ್ಮೆಂಟ್
ATL ಆದೇಶ
ಅಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಫೈನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅನ್ನ ಡ್ರಾ ಮಾಡಿದ್ರ? ಕಾಲ್ ಎಟ್ 2:30. ಫೈನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಡ್ರಾ ಮಾಡಿತ್ತು ಅಂತ ಒಂದು ಕಾಪಿ ನಮಗೆ ಕೊಟ್ರೆ ಹೇಳ್ತೇವೆ ಈಗಾಗಲೇ ಆಗಿದೆ. She is asserting.
My lords, Annexure F speaks for itself. It is the government's document. Annexure F. Annexure F. 545 PSI ಸಿವಿಲ್ ಹುದ್ದೆಗಳ ನೇರ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಯ್ಕೆ ಪಟ್ಟಿ ನೇಮಕಾತಿ ಆದೇಶಗಳನ್ನು ಪ್ರಕಟಿಸುವ ಕುರಿತು. Volume 2.
Volume 2 ಅಲ್ಲಿ.
First set, second set.
Page 535 minutes.
125. 532.
535. Annexure F, my lords.
Where is that? Where you will find that?
The subject says 545 PSI ಸಿವಿಲ್ ಹುದ್ದೆಗಳ ನೇರ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಯ್ಕೆ ಪಟ್ಟಿ ಅಥವಾ ನೇಮಕಾತಿ ಆದೇಶಗಳನ್ನು ಪ್ರಕಟಿಸುವ ಕುರಿತು. May I read out, my lords?
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಪೊಲೀಸ್ ಇಲಾಖೆಯ 2020 ಸಾಲಿನಿಂದಲೂ ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸಿವಿಲ್ ನೇಮಕಾತಿ ಪೂರ್ಣಗೊಳ್ಳದೇ ಇರುವುದರಿಂದ ಹೆಚ್ಚು ಖಾಲಿ ಹುದ್ದೆಗಳಿರುತ್ತವೆ. ಸಿವಿಲ್ ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಹುದ್ದೆಯ ಕಾನೂನು ಸುವ್ಯವಸ್ಥೆ ಕಾಪಾಡಲು ಮತ್ತು ಅಪರಾಧಗಳನ್ನು ನಿಯಂತ್ರಿಸಲು ಅವಶ್ಯಕವಾಗಿರುವುದರಿಂದ ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳ ಪಟ್ಟು ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯ ಅನುಸಾರ ಆಯ್ಕೆಯಾಗಿ ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆ ಮತ್ತು ದಾಖಲಾತಿ ಪರಿಶೀಲನೆ.
Kindly come to class 2.
Please, my lord.
Has it ever happened anywhere in the country? ತಾತ್ಕಾಲಿಕ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಇಟ್ಕೊಂಡು ಆಪರೇಟ್ ಮಾಡಿದ್ದಿದೆ.
Select.
ಬಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಏನು ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟೇ ಇಲ್ಲ.
Yes, my lord.
How you could appoint? ಬಹಳ ಅವಶ್ಯಕತೆ, ಎಲ್ಲರನ್ನು ಕೇರ್ ಮಾರ್ಕೆಟ್ನವ್ರು ಕರ್ಕೊಂಡ್ಬಂದು ಎಲ್ಲರನ್ನು ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮಾಡಿ, ಅಷ್ಟು ಅವಶ್ಯಕತೆ ಇದ್ರೆ. How can this happen?
Well, I'll take instructions.
Yeah, so many things are happening in
Please, my lord, it will set a bad precedent. Let those orders.
argued. Let us see. You written certain arguments for final hearing also. Don't expose all your cards in the cards game. How without select list? Select list illa. You have issued appointment order subject to preparing the select list.
Outcome of the writ petition ಅಂತಾನೆ condition.
Writ petition ಬಿಡಿ, ನಿಮ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಏನಂತ ಮಾಡಿ ನೋಡ್ಕೊಳ್ಳಿ. ಕಮ್ ಟು 6:30, 5:35 ಹೋದ್ರೆ ಎಲ್ಲ ಒಂದ್ ಸರಿ ಎಲ್ಲಾ ಜನರಿಗೂ ಗೊತ್ತಾಗಬೇಕು. ನೇಮಕಾತಿ ಆದೇಶ ಹೊರಡಿಸಿದ ನಂತರ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ವೃಂದ ಬದಲಾವಣೆ, ಮೀಸಲಾತಿ ಪ್ರವರ್ಗ ಬದಲಾವಣೆ, ಅರ್ಹತಾ ಪಟ್ಟಿಯಲ್ಲಿ ಸ್ಥಾನ ಮತ್ತು ಘಟಕ ಬದಲಾವಣೆ ಆಗುವ ಸಾಧ್ಯತೆಗಳು ಉಂಟಿರುತ್ತದೆ. You have not prepared select list at all.
Yes, ma'am.
And you have appointed the appointment order, issued the appointment order. You know, perhaps you will write new jurisprudence, service jurisprudence. Absolutely. Yeah, they know. It is not that they do not know, but they do as if they do not know. Issue emergent notice. ಯಾರಿಗೆ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ? ಅವರೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲಲ್ಲ.
My lords, those details are not forthcoming. We don't even know who they have issued
That
to.
happened only after filing of the application.
Application decision was reserved, my lords, at that time. This was widely reported also, my lords. And yet they did not choose to restrain. It goes against the rules,
You have said that, but we are not answering our question.
my lords.
You are not answering our question. Those who have already been issued,
Yes, my
but
lords.
they are not parties before us.
They have to provide the details of who.
Issue emergent notice. Cabinet AGA is requested to accept notice for the respondents. All respondents.
NK Ramesh.
Not additional. KE Gera. Second respondent. Call this matter along with the
Serial number 855 of 2025.
WP number. So and so.
My lords, at least till the next date of hearing, can the appointment orders issued illegally be kept in abeyance, my lord?
But they are not parties before the court. How can we pass order? You know, God gave an opportunity of hearing to Adam and Eve before punishing them for eating the prescribed apple in the Eden garden. Adam, did you eat the apple? Eve, did you eat the apple? Why did you eat? Is it not? Therefore, if God himself has given an opportunity of hearing, how can we pass an order without hearing them? If you want to amend, you make application. We'll permit you to, we'll consider that application. Yes.
May I make one request? Serial number 3 alle official ಬಂದಿದ್ದಾರೆ. Assistant Commissioner ಬಂದಿದ್ದಾರೆ.
Serial number 3. But ಏನು ಎದಕ್ಕದು?
ರಿಪೋರ್ಟ್
Compliance.
ಹೌದು. ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಇತ್ತು 4-3ಕ್ಕೆ.
ಹಾ.
ರೆಡಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹಾಕಿಲ್ಲ. ರೆಡಿ ಇದೆ ಸುಮ್ಮನೆ ಹಾಕ್ಬಿಡ್ತೀನಿ. ಪಾರ್ಟಿ ಅವ್ರು ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ಕೇಳಿ. Assistant Commissioner is present.
Whether report is filed?
Report is ready, my lord. File it. Today we'll file it.
Lordship, one humble submission. ಅದರಲ್ಲಿ ಆ ಪ್ರೈವೇಟ್ ಲೇಔಟ್ ಸರ್ವೆ ನಂಬರ್ 71 ಅವರು ರಸ್ತೆಯನ್ನು ಕೂಡ ಒತ್ತುವರಿ ಮಾಡಿದ್ದಾರೆ. ಅದರದ್ದು ಸರ್ವೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಸೊ ದಯವಿಟ್ಟು ಅದು ಕೂಡ
ನೋಡೋಣ. ಆ ರಿಪೋರ್ಟ್ ತಗೊಳ್ಳಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ರಿಪೋರ್ಟ್ ಕೊಡಿ, ಅದಕ್ಕೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ ಅವರು. ಮತ್ತೆ ಅವ್ರು ಹೇಳಿದ್ ನಿಜ ಇತ್ತು ಅಂದ್ರೆ ಯಾರನ್ನ ನಾವು ಇಲ್ಲಿಂದ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೇವೆ, ಬರ್ತಾರೆ. ಅದು ಹೆಚ್ಚು ಕಡಿಮೆ ಇದ್ರೆ ಅವ್ರ ಜಾಬಿಗೆ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗ್ತದೆ, ಮತ್ತೆ ಬೇರೆದಕ್ಕೂ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗ್ತದೆ.
ಎಲ್ಲ ಒತ್ತುವರಿಯಾಗಿ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತಾನೆ ರಿಪೋರ್ಟ್ ಇರೋದು.
ರಿಪೋರ್ಟ್ ನೋಡೋಣ, ಆ ರಿಪೋರ್ಟ್ ಕೊಡಿ.
ಮೆಮೋ ಜೊತೆಗೆ ಹಾಕ್ತೀನಿ. ಮೆಮೋ ಜೊತೆಗೆ
ಕೊಡಿ, ಮೆಮೋ ಜೊತೆ ಹಾಕ್ಬೇಕು.
ಹಾಕ್ತೀನಿ ಸರ್.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತೀನಿ ಸರ್.
ಎಲ್ಲಿದೆ ಕಾಪಿ?
ಕೊಟ್ಬಿಟ್ಟು ಹಾಕ್ತೀನಿ ಸರ್.
ಸರಿ, 2:30. Ask him to be here.
Yes, sir.
At 2:30. Very good. Next, one more point. Yes. Can we come afternoon? Yes. Very. Can we come after lunch hour? Okay. This DGFT matter. Yes, Mr. Dodmani.
Yes. Lord, the petitioner is not a BSc Agri graduate. Lord, having obtained degree, my lord, during 2003 from Ministry of Agriculture Science, Dharwad. Lord, while prosecuting final year, Lord, we have to appear for a RAVE program, that is Rural Agricultural Work Experience Program. For this, my lord, subject, the awards
need not wait. You can come my afternoon. Yes.
For this particular subject, my lord, the university awards, my lord, grade, not marks. This is from 2012 onwards, my lord, they started awarding marks even for this RAVE program.
ಮೊದಲಿಗೆ OGPA, CGPA ಅಂತೆಲ್ಲ ಇತ್ತು. Overall grade point average.
Yes.
Cumulative grade point average ಅಂತ.
Yes.
ಈಗ ಅದಿಲ್ಲ.
ಈಗಿಲ್ಲ. So my So, my lord, keeping in mind, my lord, so far as petition is concerned, annexure A4, my lord, page 45 is the mass card. Annexure A4, my lord, page 45.
ಆಯ್ತು ಬರ್ರಿ ಮಧ್ಯಾಹ್ನ ಬರ್ರಿ
ಮಧ್ಯಾಹ್ನ.
ನೋಡೋಣ. We have two more matters. Not ಸಿಕ್ಕರೆ ಇವನ್ನೆಲ್ಲ ಕಳಿಸಿ. Mr. Devdas.
Short account, 24.
24 hours.
Very short question.
My lord, serial number 15, maybe tape.
That age is saying something. Age ಗೂ ಬಿಡ್ಬೇಕಲ್ಲ. Serial number 24.
24, for
Petitioner.
respondent.
Respondent. He wants a short accommodation for the week after next at the request of learned AG final.
Please.
My lord, serial number 15 on 26th. I have informed the other side also.
You have informed the other side.
Yes.
Got it. Serial 26 here.
20. 15, serial number 15 on 26th.
Serial number 33, my lords. I'm
Ah.
appearing for respondent, my lords. I have informed other side, my lords. Statement of objection filed, my lords. 1 week.
33.
33, my lords.
ಯಾವ year?
23, my lords.
23.
Yes, my
2
lord.
weeks at the request. ಅವ್ರು ಬಂದು ಕೇಳಿದ್ರು ಅಂದ್ರೆ ನಾವು ನಡೆಸ್ಬಿಡ್ತೇವೆ ಹೇಳಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗ.
Petitioner is here.
You are here.
3.4.
Ah.
I seek for a week's time.
2 weeks.
25 also.
25 also. 25 also. Yes. Why private party is also standing there? Yes, sir. Your advocate is there.
Remember 30, 32. When is he sitting? When he wants to. He's passed over in government matter. History appeared. And then this matter that was being argued. So you probably hear only those two and I think you hear anything else. So what? We head back? Fuck. No, I want to put a company.
33.4, 2 weeks.
The response from madam.
ಅಲ್ಲೇ
ಆ ಮಾರ್ಕ್ಸ್ಗಳಿಗೆ ಕೊಟ್ಟರೆ ನಾನು reach ಆಗ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಚೆನ್ನಾಗಿಲ್ವಾ?
ಎಲ್ಲ ಇನ್ಕ್ಲೂಡ್ಸ್ ಇದೆ. ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್. ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್. ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್.
ಅದು ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಯಾವತ್ತು ಕೊಡ್ತಾರೆ ಸರ್? ಥ್ಯಾಂಕ್ ಯು.
ಇಲ್ಲ ಕೈಲೇ ಇಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 3. ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ.
ಈ ಗೇಟಿಗೆ ಹೋಗ್ಬರ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಡೇಟ್ ಹೋಗಿದ್ಯಾ?
Serial number 30 actually.
Sir, 32 erana time ತೊಗೊಂಡ್ರ ಸರ್ 32 ಇದೆ ಅಲ್ಲ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 30 ಅಡ್ಜರ್ನ್ ಆಗಿದೆ 30
Sir.
ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ ನನ್ನ ಹೆಸರು ಅಲ್ಲಂಗ್ ಹೋಯ್ತು ನನ್ನ ಹೆಸರೇ ತೋರಿಸಿ ಸರ್ ಅಲ್ಲ ಎಲ್ಲ ಕಡೆಗೂ ತೋರಿಸ್ತಾರ ಅಲ್ಲಂಗ್ ಹೋಯ್ತಾ ತೋರಿಸಿ ಅಲ್ಲ ಎಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ತೋರಿಸ್ತಾರ
ಸರ್
ಅಲ್ಲ ಇದು ಪ್ಲೀಸ್ ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಇತ್ತಲ್ಲ 8 ಜೊತೆ ನಮ್ದು 21 ಲಿಂಕ್ ಆಗಿದೆ ಅಲ್ಲ 24th ಬರ್ತಾ ಇದೆ ತಾನೆ ಎಲ್ಲ
ಸರ್ ಗುರುಗಳೇ ಅಲ್ಲ ಮತ್ತೆ ಅಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ಮೇಡಮ್ ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಕ್ಷನ್ ಆಗುತ್ತೆ ಆಗಿಲ್ವಾ Madam, serial number 4 ಅಲ್ಲಿ
Yes. Pass kare.
ಮೆಮೊ ಸ್ಟಿಚ್ ಆಗ್ತದೆ ಸಾರಿ.
Pass. Yes.
In this case, the petitioner is serving sub-inspector of police, my lords. Departmental inquiry was initiated against him basis the requisition of the CBI by their letter dated 18/12/2019, my lords. Basis which D was initiated through Annexure A1.
Why 2 applications?
My lords, the first application was filed because, my lords, after the show cause notice was issued and my explanation was provided, my lords, 14 months had elapsed. And there was absolutely no charge that was framed, for which I had preferred OA 3742 of 23, wherein a specific direction was given that the DE should be concluded within 6 months. If need be.
This is in connection with IMA.
Yes, my lords. I have been discharged in this case, as well as the CBI preferred criminal revision against my discharge as well, my lords. Even that has been rejected by the coordinate bench of this honorable court. In fact, the trial judge goes through the entire material in its detail, my lords, and the trial judge comes
Discharge ಆಗಿದೆಯಾ criminal ನಲ್ಲಿ?
ಆಗಿದೆ ಸ್ವಾಮಿ. I have produced the discharge order.
ಎಲ್ಲಿದೆ?
My lords, the discharge order, my lords, will is at page 151, my lords. 151. At page 233 is the operative portion, my lords. Para 46.
Yeah, identical charge, no? PV
Exactly
Rudrappa agattana.
It is in fact covered by judgment of the Honorable Supreme Court in this case, my lords, which is rendered on 14/12/23. My lords,
ಏನ್ ಹೆಸರು?
Ramlal versus State of Rajasthan.
Ramlal, that PV Rudrappದಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದೇವಲ್ಲ. PV Rudrappa ಇದೇನು?
PV Rudrappa, I'm sorry, I'm not carrying Ram.
Next date ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
My lord, I've received the file for the first time. It has come up for the first time. Notice maybe.
And criminal revision also I have produced, my
on
lords.
the ground of delay, the Honorable Supreme Court has relied on muscle money and also pointed out.
PV Rudrappa, do you have PV Rudrappa citation ಏನು? PV Rudrappa.
Honorable
2024. Honorable acquittal includes discharge ಅಂತಾನು ಬರ್ದೇನೆ ನಾನು.
Please.
Honorable acquittal ಆಗದೆ. ಅದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲೇ ಆಗತ್ತೆ ಇದು. Discharge is under section 227 and 228 of CRPC. Or under maybe 235 also.
My lord, there is one more.
Maybe given a short accommodation, my lord. I'll get instructions.
Just one more development.
Learned AG requested to accept notice for the respondents. Call week of.
My lords, could I request for an interim order, my lords, because the departmental inquiry is proceeding as of now, my lords. It will cause severe prejudice to me.
ಅಲ್ಲಿ entry order ಇತ್ತಾ?
ಅಲ್ಲಿ interim order ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ.
Not.
Could I just request for a date, my lord?
Bharat, ಇದು ಬಂದಿದ್ದು first time. Yes. ಫೈಲ್ ಮಾಡ್ಯಾರ? Wednesday ಹಾಕೊಳ್ಳೇನಾ? Call this matter the day after. Day after? Wednesday.
Senior is on his legs. Can
Okay.
pass over. The memo is ready. The memo is ready, my lord.
ಮೆಮೊ ಕೊಡಿ ಅವ್ರಿಗೆ ಒಂದ್ಸರಿ ಕೊಟ್ಟಿರಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕೊಡಿ. ಓಕೆ. For further hearing. Yes. Sir, anything about 22? Yes.
One small submission, my lords. The learned ASG is held up in Court Hall 1. He has been called urgently there. My learned friend can start making the submissions.
ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಫಸ್ಟ್ ಕೊಟ್ನಲ್ಲಿ?
My lords, I
ಗೊತ್ತಾಗಲ್ಲ. ಇದು ಸ್ಟಾರ್ಟರ್ ಬೇರೆ ಎಲ್ಲರೂ ಮನೆಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ. Many other urgent matters are there. Any urgency in this matter?
Not as such, my lord.
No urgency.
no.
We'll have this matter in April.
Yes, my lord, please. My lord.
No urgency as such.
No.
My lord, I'll be very honest. What had happened, my lord, is when the honorable single judge passed the order, we had sought the clearance of the goods. Part of the goods were cleared against the duty which was paid under protest. And about 2,000 odd metric tons were against the bank guarantee. The goods were cleared. Now, once the petition was allowed, my petition was allowed. The amount which was deposited by me under protest was directed to be refunded to me with interest, which have already been given to us. And thereafter, this writ appeal came along.
Then if money is also given to you,
Yes.
then let it come in regular.
My lord, because it's a legal issue, I'll be.
No, in all cases, legal issues
No,
are.
absolutely. Have it in April. I have no issues.
Sorry.
The only contention from the appellants is that, my lords,
Want
based
to
on,
argue the matter?
I'm ready, my lords. If your lordship may
No,
direct.
no, further hearing and Thakbedi. At least from parted court in the call in the third week of April. Okay. Next. All right.
My lords, the date may be fixed.
May I request for a date, my lord? I come from Delhi, that it'll be easy for me to.
But if money is already paid to you,
My lord, it's a issue which is actually going on in couple of high courts as well, because the imports were made there.
then
as
which high court's matter is going on?
well. Gujarat High Court.
Then we'll wait Gujarat High Court judgment.
No, my lord. Have
That's
it in April, my lord. I board on, my lord. My lord has urgent matters. I'm not saying
because
anything.
urgent matter, number one. Number two, you are already paid the money and you have received the interest also.
Yes, we have.
Then what actually? Only thereafter they decided to challenge that.
Absolutely. That's why I honestly brought, my lord, the update situation.
Can we push this matter in first week of June? Because now in the meanwhile, the vacation intervenes, no? Summer vacation.
My lord, may have it in April. If it doesn't happen, then we'll have it in June.
All
I can only pray for that, my lord.
Last week of April.
Can we have it, my
Please,
lord,
from
somewhere in
Parliament.
the middle so that I can get a chance if it is possible? I understand what is falling, my lord.
Let us see in the third week of anyway, you are already you have no grievance at all now. Yes. Sorry.
May I
Please
request for
from Parliament
14th
and
if
call
it
in
is?
the third week of April. Okay.
Grateful.
May I request for a date? I'm sorry, my lord, I am saying
ಕೇಸ್
again.
ಮುಂದೆ ಹಾಕಿದ್ರೆ ಗ್ರೇಟ್ ಅಂತ ಹೇಳೋದು ಆರ್ಗ್ಯೂ ಮಾಡ್ದಂಗೆ ಇರೋದು ಕೊಡಿ. Date difficult. We have difficulty in fixing date. Same thing will happen. Because when vacation is nearing, many youngsters will move the matters and they will not have any sustenance during the vacation period. And many litigants also will suffer because court will be in vacation. Many other aspects are there.
Absolutely.
Anyway, let us. Yes.
It's very small matter, my lord. So,
Yes.
my lord, as I submitted in the morning, my lord, the petitioner is, my lord, BSc Agri graduate. My lord, having obtained, my lord, the degree during 2003 from Ministry of Agricultural Science in Dharwad.
Do you have one more copy of your note?
Yes, my lord.
Nim note is one copy there, no?
ಇಲ್ಲ ಟೈಪ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕಾಗಿ
All right. He is a BSc Agri graduate.
BSc Agri graduate. My lord, having obtained the degree, my lord, during 2003.
BSc
Agri.
Agri. We
Having
agree.
obtained degree, my lord, during 2003.
2003ಗೆ OGPA CGPA ಕಾನ್ಸೆಪ್ಟ್ ಇರ್ಲಿಲ್ವಾ?
ಇರ್ಲಿಲ್ಲ, ಅವಾಗ ಗ್ರೇಡ್ ಸಿಸ್ಟಮ್ ಇತ್ತು. ಫೈನಲ್ ಇಯರ್ ಸಬ್ಜೆಕ್ಟ್ while studying final year.
ಗ್ರೇಡ್ ಸಿಸ್ಟಮ್ ಇದೆ.
Grade system.
CGPA.
Yes.
Grade system.
For-
CGPA.
Yes, CDP. That is for, it is called as RAVE, Rural Agricultural Work Experience. For this they used to give grades. After from 2012 onwards, they started giving marks for this RAVE program. Pursuant to the notification annexure A7 page 72. Annexure A7 page 72 a notification is issued by the second respondent. Annexure A7 page 72.
ಕನ್ನಡದಲ್ಲಿ
ಹೌದು, ಕನ್ನಡದಲ್ಲಿ 72. Notification is issued
English.
dated 7/2/2017.
ಅದ್ರದ್ದು ಕನ್ನಡ ಎಲ್ಲಿದೆ?
ಕನ್ನಡದ್ದು
53.
Yes.
53. ಹಾ, ನೀನು ಈಗ
ಇದರಲ್ಲಿ
ಯಾವ
this notification kindly the operative portion is on page 58. ನೇಮಕಾತಿ ವಿಧಾನ. ನೇಮಕಾತಿ ವಿಧಾನ page 58.
ಹಾ,
ಎಸ್. ಸರ್ಕಾರಿ ಅಧಿಸೂಚನೆಯ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ, ಕರ್ನಾಟಕ ಕೃಷಿ ಸೇವೆಗಳ ಸಹಾಯಕ ಕೃಷಿ ನಿರ್ದೇಶಕರು, ಕೃಷಿ
ಖಾಲಿ
ಅಧಿಕಾರಿ
ಇರುವ ಗ್ರೂಪ್ ಎ ಗ್ರೂಪ್ ಬಿ ಹುದ್ದೆಗಳಿಗೆ.
Yes. So the method of recruitment is 50% marks in the academic qualification, 50% marks in the written examination.
ಖಾಲಿ ಹುದ್ದೆಗಳಾಗಿ ಆಯ್ಕೆ ಮಾಡಲ್ಲ.
ಮತ್ತು ಗ್ರೂಪ್ ಹುದ್ದೆಗಳು ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಪಡೆದ 50% ಅಂಕಗಳು ಮತ್ತು ಅಭ್ಯರ್ಥಿಗಳು ಶೈಕ್ಷಣಿಕ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಪಡೆದಿರುವ 50% ಅಂಕಗಳನ್ನು ಆಧರಿಸಿ ಕಾಲಕ್ಕೆ ಚಾಲ್ತಿ ಇರುವ ಮೀಸಲಾತಿ ನಿಯಮ ಅನುಸಾರ ಖಾಲಿ ಹುದ್ದೆಗೆ ಅನುಗುಣವಾಗಿ ಆಯ್ಕೆ ಮಾಡಲಾಗುತ್ತದೆ. So the method of selection is 50% marks in the written examination, 50% marks in the academic examination, that is BSc Agri.
Correct.
The notification, my grievance is the notification doesn't say that the candidates who have obtained grade prior to 2012, how they are going to assess.
ಅದ್ರ ಮೇಲೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ, ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಜಡ್ಜ್ಮೆಂಟ್, ವಿಚ್ ಐ ಹ್ಯಾಡ್ ಅಸಿಸ್ಟೆಡ್. ಅನಿತಾ ದೀಪಕ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಅಥವಾ KPSC, ಇದನ್ನ ಹೇಗೆ ಮಾಡಬೇಕು ಅನ್ಕೊಂಡು ದಿ ಕೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಮೈ ಫಾರ್ಮುಲಾ. ಅದು ಓವರ್ ಆಲ್ ಗ್ರೇಡ್ ಪಾಯಿಂಟ್ ಎವರೇಜ್ ಇದ್ರೆ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು, ಕ್ಯುಮ್ಯುಲೇಟಿವ್ ಗ್ರೇಡ್ ಪಾಯಿಂಟ್ ಎವರೇಜ್ ಇದ್ರೆ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು, ಕನ್ವರ್ಷನ್ ಫಾರ್ಮುಲಾ ಏನು
ಅಲ್ಲ, ನೋಟಿಫಿಕೇಶನ್ ಡಸಂಟ್ ಸೇ.
ಅದಿಲ್ದಾಗನೇ ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಹೇಳಿದ್ರು.
The notification says in case if there is any ambiguity, it has to be as per the general recruitment rules. That is what it says. My limited grievance is while assessing the merit, they failed to give
ಅದು ಸರಿ. ಅನಿತಾ ವರ್ಸಸ್ ಎಲ್ಲ ಹೆಲ್ಪ್ ಮಾಡ್ಬೇಕು, ಬಾರ್ನರ್ ಹಂಗಿಲ್ಲ. ಅನಿತಾ ವರ್ಸಸ್ ಸೊ ಇನ್ಸೋ ಅಥವಾ ದೀಪಕ್ ವರ್ಸಸ್ ಜಸ್ಟಿಸ್ ಆರ್ ರವೀಂದ್ರನ್ ಅವರ ಜಡ್ಜ್ಮೆಂಟ್ ಗೂಗಲ್ ಔಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಐಡೆಂಟಿಕಲ್ ಕ್ವಶನ್ ಇಸ್ ಆನ್ಸರ್ಡ್ ಪರ್ಹ್ಯಾಪ್ಸ್ ಇನ್ ಯುವರ್ ಫೇವರ್. ಅದನ್ನ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಗ್ರೇಡ್ ಪಾಯಿಂಟ್ ಇರೋದಕ್ಕೆ ಅದಕ್ಕೆ ಕನ್ವರ್ಷನ್ ವ್ಯಾಲ್ಯೂ ಹೆಂಗ್ ಕೊಡ್ಬೇಕು. ಇದು ದಿಸ್ ಈಸ್ ಡಿಸೈಡೆಡ್ ಬೈ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್.
In this case, my lord, it is not followed. That is my grievance.
ಅದೆಲ್ಲಿದೆ ಅಂತ.
They say the second response says that hypothetically, my lord, I examined that even if full marks are given to you, so far as these grades are concerned, you don't come under the category of the last cutoff ranking. Thereby, my lord,
why can't you look into that judgment?
Yes, I will look into that, and I try to give notes also, my lord, so that
helps you.
Yes.
This is not a new thing at all.
Yes. Last may kindly have this matter on Monday, my lord.
ನಮ್ಮಲ್ಲಿ ರೆಡಿ ರೆಕನರ್ ಇಲ್ಲ, ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲಿ ಇತ್ತು. ನಾವೆಲ್ಲ ಅಷ್ಟು ನೋಟ್ಸ್ ಹತ್ಕೊಂಡ್ ಬರ್ಬೇಕಾಗ್ತದ.
Next Monday, my lord.
Next week?
Next week, any day convenient to all also.
Monday after next.
Please.
Monday after next. ಅಲ್ಲಿ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಆನ್ CGPA OGPA ತೆಗಿರಿ. ಅಲ್ಲಿ ಕನ್ವರ್ಷನ್ ವ್ಯಾಲ್ಯೂ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
ಎಸ್ ಮೇಲೆ
ಇದು ಡಾಲರ್ ಎಕ್ಸ್ಚೇಂಜ್ ಇದ್ದಂಗೆ ಮಾರ್ಕ್ಸ್ ಇಲ್ಲ, ಗ್ರೇಡಿಂಗ್ ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಆ ಗ್ರೇಡಿಂಗ್ ಇದ್ದಾಗ ಗ್ರೇಡ್ ನಿಂದ ಮಾರ್ಕ್ಸ್ ಹ್ಯಾಕ್ ಕನ್ವರ್ಟ್ ಮಾಡಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ ಒಂದು ಫಾರ್ಮುಲಾ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದೆ ಕೋರ್ಟ್. ಆ ಜಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬರ್ಬೇಕು, ಅವನ್ನೆಲ್ಲ ನೋಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕು.
ತಗೊಂಬರ್ತೀನಿ.
ಎಲ್ಲ ಇಲ್ಲಿ ಬಂದ್ಕೊಂಡು ನೀವು ರೆಡಿ ಆಗಿದ್ರೆ
ಫುಲ್ ಮಾರ್ಕ್ಸ್ ಕೊಟ್ರು ದೇ ಆರ್ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಅಂತ.
ಅದ್ ಮೊದಲಿಗೆ ಫುಲ್ ಮಾರ್ಕ್ಸ್ ಹೌ ಹಿ ವಿಲ್ ಅಜ್ಯೂಮ್ ಆಲ್ ದಟ್. ದೇರ್ ಇಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ನಾರ್ಮೇಟಿವ್ ಪ್ರೊಸೀಜರ್. ಇವನು ಅಜ್ಯೂಮ್ ಮಾಡೋದಲ್ಲ. ನೋಡಪ್ಪ ನಿನ್ ಪ್ರಕಾರ ನಿನ್ನ OGP CGP ನಿನ್ ಗ್ರೇಡಿಗೆ ಇಷ್ಟು ಮಾರ್ಕ್ಸ್ ಬರ್ತದೆ, ಇದನ್ನ ತಗೊಂಡ್ರು ಸಹಿತ ಯು ವಿಲ್ ಬಿ ಔಟ್ ಆಫ್ ದಿ ಝೋನ್ ಅಂತ ಅನ್ಕೊಂಡು ತೋರಿಸ್ಬೇಕು. ಅಜಂಪ್ಷನ್ ಮೇಲೆ ಮಾಡಕ್ ಬರಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ yes sir.
Website, it appears that the respondents have filed statement of objection, my lord. But copy is not served on me. I have to ascertain because it is not shown as to which respondent has filed the statement of the objection.
State has filed. State has filed. Acknowledgement email ಮೂಲಕ ಶುರು ಮಾಡಿದೀವಿ.
In this matter,
ಕೊಡ್ತೀವಿ ಸರ್.
in this matter, what has happened? Earlier, we have come on record by filing a NOC Vakala. It appears that there was
argument time ಕೊಡ್ತಾ ಇದೆ. Call after 3 weeks at the request of points. In the meanwhile, a copy of statement of objections to be served on the counsel appearing for the petitioner.
Permitted, I am ready to argue the matter, my lord.
ಓದ್ಕೊಂಬರ್ರಿ. ನೆಕ್ಸ್ಟ್ ಓದ್ಕೊಂಡು ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಬರ್ಬೇಕು ನಿಮ್ ಪ್ರಪೋಸಿಷನ್ಸ್. ಪ್ರಪೋಸಿಷನ್ ಸಪೋರ್ಟಿವ್ ರೂಲಿಂಗ್ಸ್ ಅಥವಾ ಸೆಕ್ಷನ್ಸ್ ಅಷ್ಟು ಕೊಟ್ರೆ ಬೇಗನೆ ಮುಗೀತು. ಇಲ್ಲ ಒಂದೆಯಿಂದ ಅಡಮೆಂಡಿ 8th ಆಪಲ್ ಚಿಲ್ಡ್ರನ್ ಆರ್ ಬಾರ್ನ್ ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅದು ಹಂಗೆ ಉಪಯೋಗ ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಬೇಗನೆ 25 ಮ್ಯಾಟ್ರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಎಸ್
matter relates to suspension. Yes, suspension by order dated 31/5/2024.
Inquiry reports.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Articles of charge was never issued.
Articles of charge was not issued.
Not at me.
ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಅಂತ ಹೇಳ್ತೀರಿ.
ಅಲ್ಲ, ಇದು ಹರಾಸ್ಮೆಂಟ್, ಸೆಕ್ಷುಯಲ್ ಹರಾಸ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಕಮಿಟಿ ಮಾಡಿ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ಸ್. ವಿಶಾಖ ಜಡ್ಜ್ಮೆಂಟ್ ಹಿನ್ನೆಲೆ ಇಲ್ಲ. ಹೌದು, ಇಂಟರ್ನಲ್ ಕಮಿಟಿ ಮಾಡಿ ಕಮಿಟಿಯಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. ಅದರ ಪ್ರಕಾರ ಅವ್ರಿಗೆ ಬೇರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೊಡ್ಬೇಕು ಅಂತೇಳಿ ಆದೇಶ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದರ ಪ್ರಕಾರ
ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಅದನ್ನ ಮಾಡ್ಲಿ ಅಂತ
ನಮಗ್ ಬೇರೆ ಆಪ್ಷನ್.
ಯಾರು ಲೇಡೀಸ್ ಇಲ್ದಂತ ಆಫೀಸ್ ನಲ್ಲಿ ಹಾಕ್ರಿ ಅನ್ನಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲನು.
ತಾವ್ ಹೇಳದ
yes, what are your grounds?
Under the POSH Act, it is necessary, that the inquiry that they hold be in terms of the service regulations. The POSH Act, under the Prevention of Sexual Harassment at Workplace, under the enactment itself, a provision is made that the inquiry shall be held as per the regulations, which govern the service conditions of the employee. Now, admittedly, this inquiry is not held even in accordance with that.
Illond enquiry report ide alla.
It has to be held in accordance with the service regulations.
ಅದು ಮುಂದೆ ಅದು enquiry ಬಂದಾಗ ನೋಡೋಣ. ಸಸ್ಪೆನ್ಷನ್ ಗೆ ಎಷ್ಟು ಸಾಕು.
But suspension is dated 31/5/2024. Now, more than 6 months has elapsed.
Review ಮಾಡಿ.
What has happened is, I had issued a show cause notice, against the lady. The very next day, she would register a complaint against me with the police. Admittedly, she was not a regular employee. She was only a contractual employee. She was not coming to the office on time. Page number 78, is the show cause notice that I would issue.
ಯಾರ್ಯಾರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿದೆ? ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರ್ಯಾರ್ದಾಗಿದೆ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲರದು ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಡಾಕ್ಟರ್ಸ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ. ಡಾಕ್ಟರ್ ನಾಗೇಶ್ ಅಂತ ಆಂತರಿಕ ದೂರು ಸಮಿತಿ ಸಾಕ್ಷ್ಯದಾರರ ಹೇಳಿಕೆಗಳು ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಡಾಕ್ಟರ್ ನಾಗೇಶ್ ಫಿಸಿಷಿಯನ್ ಅಂತ ಹೇಳ್ತಾರೆ, ರತ್ನಾಕರ್ ಅಂತ ಒಬ್ರು, ಮಹೇಂದ್ರ ಶೆಟ್ಟಿ ಅಂತ ಎಲ್ಲರದು ಹೇಳಿಕೆ ಆಗಿದೆ. ಇವರೆಲ್ಲೂ ಇವ್ರು ಹೇಳಿಕೆ ಕೊಡುವಾಗ ಅವ್ರ ಮೊಬೈಲ್ನ ಬೇರೆಯವರು ಯೂಸ್ ಮಾಡಿ ಮೆಸೇಜ್ ಕಳಿಸಿರಬಹುದು ಅಂತಾರೆ. ಅದಕ್ಕೂ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಕೊಟ್ಟಿದ್ವಿ. ಮನಸ್ಸಿನಲ್ಲಿ ಓದಿ, ಜೋರ್ ಓದೋದು ಬೇಡ. ಎಸ್. ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 2 unnumbered paragraph 3 ಅಲ್ಲಿನ ಟೇಬಲ್ ಬಿಡಿ, ಕೆಳಗ್ ಬನ್ನಿ, ಅದ್ರ ಕೆಳಗಡೆ ಡಾಕ್ಟರ್ ಇದಿದೆ ಅಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿ ಇನ್ವರ್ಟ್ಸ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ, ಮನಸ್ಸಿನಲ್ಲಿ ಓದ್ಕೊಳ್ಳಿ. Say this.
Can I just go through this and come back to your lordship?
Yeah.
I'll just put it to my client. This is what she says. Thereafter.
Yeah, which lady will unnecessarily?
No, my statement is also recorded, at page number 4.
ಅಲ್ಲ, ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ ಇಂಥವು ಎಂದು ನಾವು ಮಾಡಿಲ್ಲ. ನಾನು ಸದ್ಗೃಹಸ್ಥ ಅಂತಾನೆ ಹೇಳ್ತೇವೆ ನಾವು, ಯಾವಾಗ ನಾವು ಹೇಳ್ಬೇಕಲ್ವಾ?
No, but thereafter, consideration. Thereafter, the
just imagine, ನಾಳೆ ಹೆಂಗ್ ಲೇಡೀಸ್ ಸೇಫ್ ಆಗಿರೋದು ಹೆಂಗೆ? ಈಗ ಎಲ್ಲ ಲೇಡೀಸ್ ಎಲ್ಲ ಕೆಲ್ಸಕ್ಕೆ ಬರ್ತಾರೆ, ಹೌದಾ? ಅವ್ರು ನಾಳೆ ಸೇಫ್ ಆಗೋದು ಹೆಂಗೆ?
Your lordships are right. Can I just go through this and come back to your lordship? I'll just put it to my client. See, what he has to say on this. Tomorrow or day after.
ಯಾರು ಅನ್ಸೇಫ್ ಆಗ್ತದೆ?
Yes.
ನಾಳೆ ಯಾರು ಜಾಬಿಗೆ ಬರ್ತಾರೆ?
I quite see what your lordship said. I'll just put it to my client.
ಆಮೇಲೆ ಇಂಥದ್ರನ್ನೆಲ್ಲ ನಾವು ಫುಲ್ ಪ್ರೂಫ್ ಹಂಗೆಲ್ಲ ಮಾಡಕ್ಕಾಗ. ಒಂದ್ ಲೆವೆಲ್ ನಲ್ಲಿ ಏನೋ ಒಂದು ಪ್ರೊಸೆಸ್ ಆಗಿರ್ತದೆ, ಆಮೇಲೆ ಇದು ಮುಂದೆ ಏನೇನಾಗ್ತದೆ ಆಗ್ಬೋತದೆ.
But it's been more than about 8 months.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ನಾವೇನ್ ಹೇಳಿದ್ವಿ ನಿಮ್ಗೆ, ಯು ಲೆಟ್ ದಮ್ ರಿವ್ಯೂ ದಿ ಇದನ್ನ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು.
Yes.
ಈಗ ಸಪೋಸ್ ಇದನ್ನೆಲ್ಲ ಇಟ್ಕೊಂಡು ನಾವ್ ಏನಾರ ಬರ್ದ್ವಿ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಅದು ಸಿಗ್ತದೆ.
Correct.
ಅದು ಆಗಲ್ಲ.
Correct. May I just request for tomorrow?
Great. This matter day after. ಈಗ ಹಂಗ ಆಲ್ ವುಮೆನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇರ್ತಾವಲ್ಲ, ಹಂಗ ಆಲ್ ಮೆನ್ ಆಫೀಸ್ಗಳಿಲ್ಲನು ವೇರ್ ಸಚ್ ಪೀಪಲ್ ಕ್ಯಾನ್ ಬಿ ಸಚ್ ಅಂದ್ರೆ ಈ ಅಲಿಗೇಷನ್ಸ್ ಮುಗಿಯೋವರೆಗೆ. ಅದರ್ವೈಸ್ ಯು ಆರ್ ಸೆಂಡಿಂಗ್ ಫ್ರಮ್ ಎಕ್ಸ್ ಪ್ಲೇಸ್ ಟು ಅನದರ್ ವೈ ಪ್ಲೇಸ್, ಅಲ್ಲಿ ವುಮೆನ್ ಇದ್ದೇ ಇರ್ತಾರೆ. ಅವ್ರ ಸೇಫ್ಟಿ ಅದು ತಿಳಿಯಂಗಿಲ್ಲ ಸರ್ಕಾರಕ್ಕೆ.
ಎಲ್ಲಾ ಕಡೆ
ಅಂದ್ರೆ ಇಲ್ಲಿ ವಿಕ್ಟಿಮೈಸ್ ಹಾಕೋತ್ ಹೋಗ್ಲಿ ಅಂತ ಹೆಣ್ಮಕ್ಳು. ಏನ್ ಪಾಲಿಸಿನೇ ಇಲ್ಲಲ್ಲ, ಏನು ತಲೆಯಲ್ಲಿರಂತ ಪಾಲಿಸಿಗಳನ್ನ ಮಾಡ್ತಿರ್ಲ ಅಂತ. ಕೆಲವು ಆಫೀಸಸ್ ಇರ್ತಾವ ಓನ್ಲಿ ಹೆಂಗ್ ಆಲ್ ವುಮೆನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್, ಹಂಗ ಆಲ್ ಮೆನ್ ಆಫೀಸಸ್ ಇದಾವ ಕೆಲವು, ವೇರ್ ಜನರಲಿ ವುಮೆನ್ ಡು ನಾಟ್ ಡೇರ್ ಟು ಗೇನ್ ಎಂಟ್ರಿ ದೇರ್ ಬಿಕಾಸ್ ಆಫ್ ಸೋ ಮೆನಿ XYZ ರೀಸನ್ಸ್. ಎಲ್ಲ ಅಂತಲ್ಲಿ ಎಲ್ಲಾರ ಹಾಕಿದ್ರೆ ಒಳ್ಳೇದು. ಇಲ್ಲ ಇಲ್ಲೆಲ್ಲ ಆಯ್ತು, ಈಗ ಆಯ್ತು ಬಿಡಲ್ಲ, ಮತ್ತಲ್ಲೇ ಬೇರೆ ಹೆಣ್ಮಕ್ಳು ಇರ್ತಾರೆ. ಅದಕ್ಕೇನಾದ್ರು ಒಂದು ಪಾಲಿಸಿ ಮಾಡ್ಬೇಕು. UP ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೇಟ್ ಆಫ್ UP ಹ್ಯಾಸ್ ಡನ್ ಪಾಲಿಸಿ. ತರ್ಸ್ಕೊಳ್ಳಿ, ಅಲ್ಲಿಂದ ತರ್ಸ್ಕೊಂಡು ಮಾಡಿ. ಗ್ರೇಟ್. Otherwise, the predatory habit of man that does not cease because only place is changing. Man continues to be, which Ralph Waldo Emerson said 2000 years ago, man was an uneducated rascal. Today he is a literate rascal anta ಹೇಳಿದ್ರು, which in Salmond Hobbes Leviathan ದಲ್ಲಿ ಬರುತ್ತಲ್ಲ, man is a first grade criminal. These truths you have to make the laws. ಅಪೋಸ್ ಆ ರೀತಿ ಟೆಂಡೆನ್ಸಿ ಇರುವಂತವರಿಗೆ ಅವ್ರನ್ನೆಲ್ಲೇ ನೀವು ಕಳಿಸ್ಬೇಕು, ಏನ್ ಮಾಡ್ಬೇಕು, ಇದೊಂದು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಪಾಲಿಸಿ ಮಾಡಿ. ಅವ್ರಿಗೂ ಅನ್ಯಾಯ ಆಗ್ಬಾರ್ದು. ಕೆಲವೊಂದ್ಸರಿ ಸುಳ್ಳು ಅಲಿಗೇಷನ್ ಮಾಡಿ ಮಾಡೋದು ಪಾಸಿಬಿಲಿಟಿ ಇರ್ತದೆ. ಬಟ್ ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಒಂದು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಪಾಲಿಸಿ ಮಾಡ್ಬೇಕು. ಅದರ್ವೈಸ್ ಹೌ ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ಎತ್ರನರಸ್ತು ಪೂಜ್ಯಂತೆ ತತ್ರ ರಮಂತೆ ದೇವತಃ, ಹೆಣ್ಮಕ್ಳಿಗೆ ಎಲ್ಲಿ ಗೌರವ ಸಿಗ್ತದಲ್ಲಿ ದೇವರು ಇರ್ತಾನೆ, ಏನು ಎಂಟಿ ಸ್ಲೋಗನ್ ಆಗ್ತದೆ. They should feel secured. They should feel we are in secured premises. Maybe that much work is extracted from us, but we are absolutely at the very safe hands of the unspeakable. ಅದಕ್ಕೆ ಏನಾರ ಮಾಡ್ಕೋಬೇಕು. Call day after at the request of. Yes.
Suspension.
Yes. What's the ground, Simraju?
Ground is Milan. After lapse of 24 years, Milan, complaint was lodged. On 21 to 1997, he was appointed as a teacher.
1997.
21 to 1997.
1997, February 21.
Please, Milan, as a physical education teacher. But complaint was lodged on 19/8/2021. Saying that, Milan, that appointment at the time of appointment, I issued, given fake marks card.
Fake marks.
Please, my CPAT marks card is not, marks is 808. Lordship already once matter was came up.
Ondsari here.
Lordship has directed to furnish this duplicate marks card. I produced the duplicate marks card. CPAT marks not 808 I secured. That marks card only I have submitted. 808 into rent.
Out of festival.
Out of blood, that is
1,200.
1,200. I got an appointment on 1997.
Yes.
Still I am working. But on 19/8/2021, not one private complaint was lodged by one Channikeshwamurthy. Saying that I produced the fake marks card and obtained the job. That duplicate marks card also I produced before Lordship direct as per Lordship direction to the government authority. Till today, they have not examined. I secured the marks card from the competent authority and produced the
original marks card.
808.
Original marks
808. Only 808. 808. But preliminary inquiry was conducted.
ಬೇರೆ ಕಂಪ್ಲೇಂಟ್ ಏನ್ರ ಇದಾವನು?
No other complaint.
There is no forthcoming from the records, my lord. As based on the records, there are no other complaints.
No other complaints.
But based on the preliminary inquiry, he has been selected based on his marks being 880.
818.
880, my lord.
808.
880.
880.
880.
880.
Not 808.
Yes, my lord. Page 59 is the typed copy of the.
ನೀವು 880 ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇದೀವಿ.
Final list ಅಲ್ಲಿ that is the basis on which he has been selected, madam. However, his marks card
shows 808.
808.
808 ಆಗಿದ್ರೆ ಇದಕ್ಕಿಂತ ಕಡಿಮೆ ಇರೋರು ಯಾರಿದ್ರು? ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇರೋರು ಯಾರಿದ್ರು?
Preliminary inquiry was conducted.
ಇದಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಂತವ್ರು ಯಾರಾದ್ರೂ ಇದ್ರ ಸೆಲೆಕ್ಷನ್ ಫ್ರೇ ಅಲ್ಲಿ?
Above 808, my lord. Above 808, there are several, my lord. But at the next page 50, page 58, my lord. But there is a typed copy only of the relevant portion at page 59, my lord.
Eight eight zero. ಯಾರು ಇಲ್ಲ 611 675 574 ಇದ್ದಾರೆ.
560 765 last
50.
ರಮೇಶ ಗರುಡರ ಸ್ವಾಮಿ ಎಂತದು ಗುರುಡರ ಸ್ವಾಮಿ ಪಾಂಡುರಂಗ ರಾವ್ ಗೋರ್ಪಡೆ ಮಾದಪ್ಪ ಮ್ಯಾಲರೆಲ್ಲ ಇವನ್ಕಿಂತ ಕಡಿಮೆ 880 ಕಡಿಮೆ ಇದೆಯಲ್ಲ.
900 ಅಂತ ಇದೆ ನೋಡಿ ದಯವಿಟ್ಟು. 900 ಅಂತ ಸೀರಿಯಲ್ ನಂಬರ್. ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ದೇ ಆರ್ ನಾಟ್ ವೆರಿ ಲೆಜಿಬಲ್. 900 ಅಂತ ಒಂದಿದೆ ಸ್ವಾಮಿ. 1 2 the fourth one, my lord.
ಯಾವ ಪೇಜ್ ನೀವು
page 58, my lord.
58.
This is along with the statement of objections filed before the tribunal, my lord.
He belongs to group 3A, my lord. 745 is the last cutoff marks.
745 is the
745.
cutoff marks.
Kindly come to page 58 ಅಲ್ಲಿ, the serial number 39 my lord.
39.
39 ನಲ್ಲಿ one lady last ಗೆ 765 bar 1200 my lord.
765
Bar 2200.
ಅದೇ cutoff.
ಅದು ಲಾಸ್ಟ್ 3A ನಲ್ಲಿ.
ನಿಮ್ದು 3A ನಾ?
Please not 3A.
765.
765 bar 1200.
8/11/72 date of birth.
Please not.
Candidate.
Please.
ಏನ್ ಹೆಸರು? ಶೈಲಜಾ. ಚಿನ್ನಪ್ಪ.
ಲೋಹಿನಾ ಚಿನ್ನಪ್ಪ.
ಚಿನ್ನಪ್ಪ.
ಲೋಹಿನಾ ಚಿನ್ನಪ್ಪ.
ಅದು ಇನ್ನೊಂದು ಕ್ಯಾಂಡಿಡೇಟ್. Yes, brother, what is funny? Assuming that he had 808 only.
But,
Preliminary
pending inquiry now, the prima facie evidence suspension can be as per rule 10(3) of the
Where
CCA
is
rules.
the minimum requirement of inquiry? Assuming
Please.
that he had secured only 808, whereas marks card said 880.
Marks
But,
card says 808.
Next below is 765. Where is the case for any inquiry?
But the marks card says 808.
808. 808 is above 765. Where is he has not taken away anybody's job. ಆಮೇಲೆ ಒಂದು ಎಷ್ಟು ವರ್ಷದ ಮೇಲೆ? There is always, you have to give some concession to the shortness of human life. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಈಗ ಇದ್ಕೊಂಡು?
24.
ಮಾರ್ಕ್ಸ್ ಜಾಸ್ತಿ ತೋರಿಸಿ ಇನ್ನೊಬ್ಬರಿಗೆ ಡಿಸರ್ವಿಂಗ್ ಕ್ಯಾಂಡಿಡೇಟಿಗೆ ಅನ್ಯಾಯ ಆಗಿ ಇವ ಮಾರ್ಕ್ಸ್ ಜಾಬ್ ಮಾಡಿದ್ರೆ we can understand. Even as per the merits, he is the more meritorious candidate than the next below. Where is the case for prima facie case for inquiry, let alone suspension?
It may be a victimless crime, my lord, but
Because he had produced that.
but an attempt was made to commit fraud,
No.
which can come, the truth of which can be determined only through an inquiry, my
A
lord.
suspension act.
And already it's nearing 6 months, my lord.
months.
Deem revocation will be coming into effect in another, on 25th of this month, my lord.
25th.
Please, my lord.
Call this
If it-
matter on 26th. 26th.
In the meantime, I will get instructions on what has exactly happened. If there is anybody else who has suffered because of this,
ಅವಾಗ ಒಂದು
I'll
after how
specifically
many
put that
years?
question and get an.
After how many years? ಅಲ್ಲಿ
On
job
this
secure-
aspect, my lord, the law laid down by the Honorable Supreme Court is that including division bench of this Honorable Court, my lord, fraud vitiates
ಅದಕ್ಕೆ ಅದು ಲಾರ್ಡ್ ಕೋಕ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ದಟ್ಸ್ ಆಲ್ವೇಸ್ ಟ್ರೂ. ಬಟ್ ಅದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಇದೆ. ಫ್ರಾಡ್ ವಿಷಿಯೇಟ್ಸ್ ಎವ್ರಿಥಿಂಗ್ ಅನ್ಕೊಂಡು ನಾವು ಬಾಬರ್ ಇಲ್ಲಿ ಬಂದಾಗ ಏನಾಗಿತ್ತು, ದಟ್ ಈಸ್ ವಿಷಿಯೇಟೆಡ್ ಹಂಗ ಆ ರೀತಿ ಬರ್ತದೆ.
One judgment my
I
lord.
will examine, my lord.
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಕೊಡಿ.
I will
1998 judgment. Inordinate delay my lord in service condition could not be ಅಂತಲೇ ಬರೆದ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ.
ನೋಡ್ ಈಗ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ
Lord,
ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ,
No, my lord.
ನೀವು ಇನ್ನೊಬ್ರು ಜಾಬ್ ತಗೊಳ್ಳಿ ಬಿಡ್ಲಿ, ದ ವೆರಿ ಉದಾಹರಣೆಗೆ ನಾನು ಕೌಂಟರ್ ಫೀಟ್ ಕಾಯಿನ್ಸ್ ಅನ್ನ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಮಾಡೀನಿ, ಬಟ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಪುಟ್ ದೆಮ್ ಇನ್ ಸರ್ಕ್ಯುಲೇಷನ್.
Original marks card
No.
is with the appointing authority. I produce the original subsequently also. Till then,
First
Lord, at least stay, my
First week
lord.
of April.
Stay, my lord, at least, my lord, the order of suspension.
ನೋಡೋಣ. 6 ತಿಂಗಳಾಗಿದೆ, ರಿವೋಕ್ ಮಾಡ್ಕೊಂಬನ್ನಿ ಅದು.
Please.
ಎಸ್
Lord, I prefer the respondent to this matter.
ರಮೇಶ್.
I seek for a short pause over my lord, the senior counsel services ತಗೊಂಡು. One 15 minutes.
3 days, madam, he is seeking pass over, then afterwards,
ಇಲ್ಲ,
madam, tomorrow.
ಹಂಗೇನಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್
But the only issue, short point.
ಒನ್ ಡೇ ಹಾಕೊಂಬೋಣ, ಅವತ್ತಿನ ದಿವಸ ಆರ್ಗ್ಯೂ ಮಾಡಿ.
Please,
Retirement
please.
is-
ಸರಿ ಟೈಮ್ ತಗೊಂಡಿರ ನೀವೀಗ.
ಹೌದು, pass over.
But only issue is madam
ಅದಕ್ಕೆ
competence.
ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಮಂಡೇ at the request of so and so. Finally, on
Please.
that day, Mr. Ramesh shall not seek
Please.
adjournment or passover.
Please.
Okay, ಎರಡನ್ನೂ ಕೇಳಂಗಿಲ್ಲ.
Please,
Okay,
please.
next. Yes, Manish Kumar.
One office objection in respect to interoperability was kept open, my lords.
ಏನಿದೆ ಮ್ಯಾಟರ್ ವಿ ಡೋಂಟ್ ರಿಮೆಂಬರ್. ನಾವು ಇದು ಹೇರ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಇಲ್ಲ. Yes.
Earlier it was heard, my lords, it was reserved for judgment. However, my lords.
By us?
No,
Not
by
some other
coordinate
bench.
Then again, my lords, it was heard and reserved by another coordinate bench. The judgment could not come to be delivered. So, my
You
lords,
argue, we'll hear and we'll give the judgment.
please.
Yes.
My lords, the case is something like this.
Yes.
The affairs of the cricket, so BCCI, the Board of Cricket for Control in India, the Cricket Association of Bihar, reached the platform of the Honorable Apex Court.
ಮೈಕ್ ಸರಿಯಾಗಿ ಇಟ್ಕೊಳ್ಳಿ.
Please, it reached the platform of the Honorable Apex Court.
ಇಲ್ಲ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಏನು ಅಂತ ಇನ್ನೊಂದ್
The affairs of the Board of Control for Cricket in India, BCCI reached the holy platform of the Honorable Apex Court.
Correct.
The Apex Court, my lords, was quite, my lords, disturbed, please, my lords, at the happenings in the affairs of the Board of Cricket Control, particularly, please, my lord, the concentration of power that people were continuing, please, my lords, to hold offices, my lords, for ends of time without any break and without any fetters on number of terms that they would, my lords, be permitted to contest for the election, so on and so forth, my lords. It constituted a committee called the Honorable Justice Lodha Committee. Three other judges, please, my lords, of the Honorable retired judges of the Honorable Supreme Court were co-opted as members. The committee was directed, please, my lords, to place the rule book also, please, my lords, which would be engrafted and placed before the Apex Court, which is accepted by the Honorable Apex Court to be my lords, the rule book of the BCCI.
Yes.
The same thing, please, my lords, was directed to be adopted, please, my lords, by all the state associations. The issues, please, my lords, which are urged before my lords for consideration are, my lords, which is accepted and ratified by the Honorable Apex Court are, after every 2 terms, please, my lords, a member has to undergo a cooling off period for 1 term.
He cannot.
He cannot contest the election again.
Like American Constitution.
Yes, please, my lords.
Yes.
And after 2 terms, my lords, after cooling off period, he can contest for 1 more term. That is total period of 9 years. There is no, please, my lords, he cannot hold any office, please, my lords, after 9 years.
ಅದಾದ್ಮೇಲೆ ಮುಗಿದೋಯ್ತು.
ಮುಗಿತು, ಕೆಲಸ ಮುಗಿತು. ಅಲ್ಲಿ state association, you can go to the BCCI. Thereafter, you can not hold office in the BCCI. That is, again, there also, please, my lords, 3 terms you will get. That is one aspect of the matter. The second,
ಇದು BCCI is an Article 12 entity.
ಅದೇ ಇದರಲ್ಲಿ ಇದೇ judgment ಅಲ್ಲಿ Supreme Court holds it is maintainable.
It is maintainable.
It is maintainable against the Board of Control for Cricket in India.
ತೋರ್ಸಿ ನೋಡು.
ಇದೇ judgment annexure A ಅಲ್ಲಿ ಇದೆ.
ಕೊಡಿ.
Not subject to Article 12, but amenable to 226, my lords. Respectfully,
Page
would
number
be the position.
34.
Article 12 ಅಂದ್ರೆ part 3 ಗದು ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್. But 226 ಬಂದಾಗ
Please,
if it has ಸ್ವಲ್ಪ different complexion ತೋರ್ತದೆ, it is maintainable.
please.
Though it is not
When a public question comes to be involved.
involved. Therefore, that question has to be answered in his favor only. So maintainability of writ petition ಮೇಲೆ ಏನರ issue ಇದೆಯಾ?
There is, my lords. In fact, it was kept open and now the petition may
Kept
have-
open by whom?
my lords, this honorable court,
By this court.
the first order on 23/11.
No, but that question now pales into insignificance.
Please.
Because you admit that writ petition is maintainable.
No, in this case, I say, in fact, I filed a note that writ is not maintainable. But my lords, I was only,
ಎರಡು aspect ಇದೆ.
please,
Writ petition is not maintainable is one thing.
Please.
That means he cannot knock at the doors of the court at all.
yes,
It's a threshold bar.
yes, my lords.
The other one is writ petition is maintainable, but no relief can be granted to him is another.
My submission would be writ petition is not maintainable at all.
At all, threshold bar.
Threshold.
On what ground?
Your lordship may kindly see the prayer. The prayer is, he is seeking for quashment of an order of the learned ombudsman. My first submission is that ombudsman is not a tribunal or a court for this honorable court to exercise 226, 227 jurisdiction.
What is the effect of ombudsman's order? What legal consequences follow from that order?
Lords, my respectful submission is, he made a complaint before the ombudsman.
No, we're not on the process. You tell us,
Please,
what are the legal consequences,
please, my lords.
implications,
Please,
repercussions
please, my lords.
of this order?
The only repercussions are that election is not disturbed.
Then writ petition is maintainable.
Lord.
If ombudsman is deciding
Please,
the validity of elections, regularity of elections,
please.
then he is amenable to writ jurisdiction.
a similar issue came up before the Telangana High Court. In these peculiar circumstances, the Telangana High Court says, no, the only remedy is to file a civil suit. But if I may submit in sequence as to why, my respectful submission is the ombudsman is not appointed by the state. The ombudsman is not appointed by the judiciary. The ombudsman, in fact, is not even appointed by the parties. He is elected under Article 40.
How he came ombudsman?
He was created by the apex court, please.
Was created by the
Apex court.
Modlu, there was an arbitrator earlier. That arbitration clause gives way to appointment of an ombudsman. Therefore, my lords, my respectful submission is that this ombudsman, because of the augustness of the position, the parties go submit. That's why, my lords, the importance of the word ombudsman. Adjudicator is not chosen, arbitrator is not chosen. The language employed is ombudsman.
So
That
that his orders can never be challenged.
Not the only remedy is he has to file a civil suit. It's a
What
society.
is the duration of the tenure election duration is
3 years.
ಯಾವ suit 3 ವರ್ಷ ಮುಗಿತದಲ್ಲ.
In fact, in this case, elections are long over. The next elections will be held in this December. So the matter has become infructuous.
It will be rendered infructuous, I can understand. Which suit we have decided within 1 or 2 years? Impossible.
Suits don't get resolved.
ಮತ್ತೆ ಆಗ ಹೋಗ್ಲಿ ಹಂಗೆ ಗ್ರಿಟ್ ಮಾಡ್ಲಿ. Ombudsman ಅನ್ನೋ ಕಾರಣಕ್ಕೆ he does not enjoy immunity from judicial scrutiny. In writ, if in suit he can be looked into, writ court also can look into that.
I will show, my lords, as to.
May I just make one
Sonia,
submission in this
thereafter,
context?
please
Lord, I'm
note
not
the rule book was
coming in the
late.
way of.
The fetters.
I'm sorry. Can I just,
Eddie,
Lord,
Nandakumar,
only on this
yes.
point? Lord, insofar as maintainability, etc., I would only say this, my Lord, if your lordships permit me. I appear for the KSCA, that is respondent number 8 in the writ petition. Now, my Lord, my submission would be like this. I am not for a minute saying that your lordships would not have oversight under 227. Of course, your lordships, Lord, to say that that is taken away, it would be a fairly dramatic submission, and that's not what I would submit. Perhaps what I would say is that the ombudsman is meant to be a dispute resolution mechanism for members inter se within, my lord, the bylaws of the society. Consequently, perhaps the first port of call should be the suit court rather than a writ court is perhaps the way I would subscribe it, my lord, rather than to say that no, my lord, this thing. I perhaps your lordships may what fell from the court also suit within 3 years, etc. Now, of course, you are saying
Every suit will be defeated.
No, I bowed.
Every
I bowed
suit,
on that. I bowed on.
issue frame ಆಗೋದ್ರಲ್ಲಿ
now we are seeing some speed in commercial courts.
ಮತ್ತೆ issue frame ಆಗೋದ್ರಲ್ಲಿ ಮತ್ತೆ 3 ವರ್ಷ
I
permanently
bowed.
there will be no remedy to ಇಲ್ಲಿ ನಾವು ಕೊಡ್ತೇವೆ ಬಿಡ್ತೇವೆ that's another
ಅಲ್ಲ,
thing.
ಅದು ಬೇರೆ.
We were to say
I'm not on
ಇದು
that.
ಅಲ್ಲಿ ಹೋಗು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗು ಅಂತ ಹೇಳಿ
I'm not. I'm only saying
ಯಾರಿಗೆ ನಮಗೆ ಆಗಲ್ಲ.
for whatever reason, commercial proceedings have been given some advantage, but that is not available to our regular civil proceedings. I don't want to say more than that.
Yeah.
The second submission to advance, my lord, for your lordship's kind consideration is what was in challenge in this writ petition relates to the my lord, the elections of a year that have now come and gone. Thereafter, fresh elections were held 2 years ago. And in that, none of the private respondents against who the petitioner has a grievance have been elected. Therefore, in that background, whether your lordship would still like to consider or not, I leave it to your lordship. That's what I would want to bring to your lordship's notice.
No.
There's a memo to that effect filed. I just wanted to place that for your lordship's kind consideration.
Let us. Yes. Others ಏನು wait ಮಾಡೋದು ಬೇಡ ಯಾಕಂದ್ರೆ ಇವತ್ತು we have some function also. So we have to give rest of the people entry model continue ಮಾಡೋಣಂತೆ ಕಾಯೋದೇನು ಬೇಕಿಲ್ಲ. ಬಹಳ ಅರ್ಜೆಂಟ್ ಇರುವಂತದ್ದು EGA.
RPF has been.
RPF.
For number has been given.
ಯಾವುದು?
First item, serial number 1, the review petition.
Review petition.
We have filed, RPF. FR number has been given.
Review petition. Okay. Next week ಹಾಕೊಳ್ತೇವೆ. First matter. ಭಜಂತ್ರಿದು. Okay. The order was made long ago.
In June
24.
June 2020. 3 months time.
Next week. ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 15 ಎರಡನ್ನು ಜೊತೆಗೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಬರ್ಕೊಡ್ರಿ. ರಿಜಿಸ್ಟ್ರಿ ಟು ಪೋಸ್ಟ್. ಅದು ನಾಳೆ ಒಂದು ಮೆಮೊ ಕೊಡ್ರಿ. ಒಂದು ಮೆಮೊ ಕೊಡಿ, ಇವತ್ತೇ ಮೆಮೊ ಕೊಡಿ, ಅದ್ರ ಜೊತೆ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ. ಆಲ್ ರೈಟ್, ಎರಡು ಬರ್ರಿ ಜೊತೆಗೆ ನೋಡಿ. Yes.
My lord, can I also seek indulgence in serial number 32 in which I am appearing, if your lordships can kindly give any short date, my lord, because he's been out of employment now for a very considerable period of time. And now there is an opening that is available owing to the death of another person, my lord. There's a scheduled tribe candidate. If your lordships may kindly consider within this week any date, I'll be very grateful.
ಆಮೇಲೆ ಯಾವ್ದಾರ ಒಂದು ಬೇರೆ ಡೇಟ್ ಕೊಟ್ಕೊಂಡು
I'm very grateful.
ನೋಡ್ಕೊಂಡು ಆಮೇಲೆ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ನೋಡಿ ಕೇಸ್ ಏನು.
Government has granted promotion and there is no provision for granting promotion that was granted there. However, there is a interim order that may be the promotion was granted here non-existing.
We'll have it in first week of April when date comes. ಆ ಡೇಟಿಗೆ ನೀವು ಎರಡು ಸೈಡ್ ರೆಡಿ ಇರ್ಬೇಕು. ಇಷ್ಟೇ ಪಾಯಿಂಟ್. ನೋಡಿ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಸ್ಟಾರ್ಟ್.
Interim order may be extended.
Wherever interim order is there, interim order.
May I make one request, I'm sorry.
ಆಯ್ತಲ್ಲ ಇದು ಸ್ಟಾರ್ಟ್
40 minutes, 40 transfer matter minutes for the last 4 months minutes. Serial number 40.
ಅದು ನೋಡಿ
Request.
ಹೌದು ಪೃಥ್ವಿದು
Great.
after 2 weeks.
Serial number 41, commissioner are going to retire in the month of
December?
This month only.
This month only. ಏನದು ಮ್ಯಾಟರ್?
Promotion ಕೇಳಿದ್ದೇವೆ that the matter pertains to departmental inquiry. They have sought for promotion. Some urgency, next week, Monday
ಹಾಕಿ
41.
All right. Monday, Tuesday ನೋಡ್ಕೊಂಡು ಹಾಕೊಳ್ಳಿ. At least reach ಆಗೋ ರೀತಿ. Yes.
Serial number 30.
Yes, Manish Kumar.
Please.
Serial number 34. Serial number 34, my lord, 2 weeks.
I am in the respondent in that matter. There is also, there is a promotion that they have filed and they have not mentioning anything.
ಯಾವಾಗ ಪ್ರಮೋಷನ್ ರಿಟೈರ್ಮೆಂಟ್ ಯಾವಾಗ?
Pending of this month itself, they are denying the promotion.
No, ರಿಟೈರ್ಮೆಂಟ್ ಯಾವಾಗಿದೆ?
Within the one year.
1 year ಇದೆ. ಅದು ನೋಡಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಹಾಕಿ.
Serial number 3 ಅಲ್ಲಿ ಸರ್, ಕಾಪಿ ಟು ಅದರ್ ಸೈಡ್ ಅಂಡ್ ಫೈಲ್ ಇಟ್ ಮೇಲೆ.
3
serial number 3 ಅಲ್ಲಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿರಾ? ಈಗ
ಸರ್ವ್ ಮಾಡಿ ಫೈಲ್ ಮೆಮೊ ರೆಡಿ ಆಗಿದೆ, ಸರ್ವ್ ಮಾಡಿ ಫೈಲ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸರ್.
ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವಾಗ? ಮಂಡೇ. ಆಲ್ ರೈಟ್, ಮಂಡೇ. Yes, start.
Please, may I, my lords? Now, what transpires, please, my lords, what the apex court said was.
You are challenging the order of the ombudsman.
Ombudsman, please, my lord.
Where is
My
that order?
grievance is, my lords, I will just, my lords, in a small nutshell, please, my lords. R3, please, my lords, has been nominated as to the managing committee for 3 consecutive years. 3 terms of 3 years.
Vinay Mrutyunjay.
Yes, 3 terms of 3 years, 9 years he is completed. And R4, please, my lords, has been assistant secretary from 2016 till 2019. Thereafter also he has been elected for 1 term. So 2013 to 2019 is 2 terms of 6 years. 2 terms, my lords, total completed. He'll have to give a cooling off of 1 term. He could not have contested in 2019. That is my submission, because 2013 to 16, 2 terms he has been assistant secretary. He has to give a cooling off, he has to observe a cooling off of 1 term. That is my respectful submission. R5, please, my lords, is holding an elected political appointment. So, my lords, the Supreme Court has specifically kept away all these political nominees. My lord, they should not, my lords, come to the administration of cricket. That is the specific observation of that is incorporated in the rule book also. And R6, please, my lords, he represents an institutional club. 6 years, my lords, they have completed 2 terms. They have to observe a cooling off period of one term. So this is my, as regards to these persons, please, my lords, either the R3 has not completed his term. He cannot no longer stand for elections at KSA. He'll have to go to the BCCI. 3 terms, 3 years completed. 9 years is over. That is the threshold. And R4, please, my lords, 6 years complete, 1 period of cooling off. R5 again, please, my lords, political appointee. He cannot hold the affairs.
Political
office.
appointee ಅಂದ್ರೆ ಏನು?
A member of Legislative Council. He has subsequently resigned. That is another aspect. And R6 also, my lords, cooling off, and R7, please, my lords, is the BCCI. Same thing, please, my lords, institutional club. And this on the background, please, my lords, may I respectfully submit. The only two things, my lords. After 2 terms, my lords, 1 cooling off period. After 3 terms, my lords, you can no longer hold any post in the affairs, please, my lords, of the BCCI or the KSCA, as the case may be. So if you are contesting for election at KSCA, 9 years is the threshold bar. After 9 years, my lords, you will have to, you cannot no longer contest.
It's a complete bar.
Complete bar. That is my respectful submission.
ಅದೆಲ್ಲಿದೆ ಕಂಪ್ಲೀಟ್ ಬಾರ್ ಅನ್ನೋದು?
The rule book ಅಲ್ಲೇ ಬಂದ್ಬಿಡುತ್ತೆ.
ತೋರಿಸಿ. ಅಂದ್ರೆ ಬೈಲಾಸ್ ನಲ್ಲೇ ಇದೆಯಾ?
ಹೌದು. Page number 334. H. 334. Page number 334 ಅಲ್ಲಿ
9 years.
9 yes, has been an office bearer of the BCCI for a cumulative period of 9 years or a state association for a cumulative period of 9 years.
Yes.
Explanation. Period of 9 years contemplated above BCCI and association mutually exclusive. Thus, it is clarified that the person may be able to serve a period of 9 years in the BCCI and 9 years in the association.
ಒಂದರಲ್ಲೇ 9 years ಆಗಂಗಿಲ್ಲ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಮೋರ್ ದೆನ್ 9 years ಆಗಲ್ಲ.
ಹೌದು. BCCI ಇದ್ರೆ 9 ವರ್ಷ ಕಂಟೆಸ್ಟ್ ಮಾಡಬಹುದು. KSCI ದಲ್ಲಿ 9 ವರ್ಷ ಕಂಟೆಸ್ಟ್ ಮಾಡಬಹುದು.
ಒಟ್ಟು 18 ವರ್ಷ.
18 ವರ್ಷ.
ಮ್ಯೂಚುವಲಿ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್.
Mutually exclusive. And an office bearer, an office bearer who has held a post for 2 consecutive terms, either in the association or in the BCCI, or a combination of both, shall not be eligible to contest any further election without completing a cooling off period of 3 years. During the cooling off period, such person shall not be a member of the governing council or any committee whatsoever of the BCCI or of the association. The expression office bearer should not be permitted to be circumvented by being a member of any other committee of the governing council in BCCI or the association, as the case may be. Okay. So, and at C, D is a minister of a government servant or holds a public office. So, public office, he was a member of the Arya Vaishya, he was chairman of the state-owned Arya Vaishya committee, some organization. So that not we say it is a public office because he is drawing perks and salaries from the government. He uses the official car also. So therefore, he is holding a public office. So we are saying R7 millards is disabled to contest.
He is MLC.
Now he is MLC. After becoming MLC, he resigned.
Person shall be disqualified being an office bearer. He is no longer. Now there is nothing, no relief. But when it's office where the state gives a lot of grant and all that, it is totally state-owned organization for the upliftment of the Arya Vaishya Mahasabha, cabinet ranking minister, some on par status. So he was drawing salary also from the state. So our contention is he could not have millards held office, please millards, on the rolls of the. ಈಗ ಇರುವಂತ ಯಾವುದೇ ಆಫೀಸ್ ಬೇರರ್ಸ್ who are now presently in holding the tenure.
ಈಗ ಯಾರು ಇಲ್ಲ. Now the period has gone. Avaka, when they contested and they were permitted, it is something like this. When they filed their nominations, my grievance was, look, listen, you have completed 3 years or you have to take a cooling off period of 1 term. I approached, please, my lords, the returning officer. The returning officer did not heed to my request. Thereafter, my lords, under the constitution itself,
went
there
to
is
ombudsman.
I approached the ombudsman and I filed.
Ombudsman of the provisions, Torsi.
Swami,
how ombudsman is constituted?
He is created, my lords, by the order of the apex court. He is a former judge of this honorable court.
Yes.
And he will hold office ombudsman, please, my lords, at page number 320.
320.
The definition is at page number 320. That is the independent grievance redressal authority set up under chapter 9.
Double E.
Swami. Double E.
How double E gained the entry to rule book?
Swami, ಅದರಲ್ಲಿ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, the apex court said the BCCI will have an ombudsman who is a retired judge of the Honorable Supreme Court, and the state associations likewise will have a ombudsman
Of High Court.
who will be a retired judge of the respective High Court. Although that is in the decision of the apex court. That has been followed.
Do you dispute this position?
No, my lord. My learned friend is right, my lord. In fact, it's been incorporated into the bylaws at Rule 40, bylaw 40, page 361. Your lordship should get it. My learned friend is correct in saying that the Honorable Supreme Court contemplated the constitution of an ombudsman.
362.
I'm sorry, my lord. There is some fluctuation in the page number.
All right, no issue. Para 40.
Para 40, bylaw 40, quite fine. This was incorporated pursuant to the Supreme Court judgment. To that extent, my learned friend is absolutely right.
But Monesh Kumar will never mislead the court. Even if it goes against him, we will say. Yes.
Please. Now, my lords, as things transpire, please, my lords, my respectful submissions are that the R3 had completed his 3 years term. I have already said that, please, my lords. Based on this, please, my lords, I made a specific grievance, please, my lords, before the returning officer. It was rejected. Then I came up before the Honorable Ombudsman. The Honorable Ombudsman is also pleased, my lords, to reject my claims, stating, please, my lords, that they are entitled to contest. Aggrieved, please, my lords, I am before my lords.
How Ombudsman comes to the conclusion that they are entitled to contest?
Our annexure L, please.
Our reasoning is let us see.
Please. Annexure L. Page number 716.
716, volume 2, na?
How so? Or as regards to, please, my lords, the present respondents at point number 2, para 34 onwards, please, my lords, has been answered, please, my lords, by the Honorable Ombudsman.
Volume 2.
Page 720.
722.
Para point for consideration. That has been answered. ಒಂದ್ಸತಿ 2 ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಹಾಕು ಅಂತಂದ್ರು, ಅವಾಗ ಸ್ವಲ್ಪ ಮಿಸ್ ಆಯ್ತು. ಸೊ ನನಗೂ ಅದಕ್ಕೂ ಸ್ವಲ್ಪ ಚೇಂಜ್.
ಇದು ಫಸ್ಟ್ ವಾಲ್ಯೂಮ್ 600 ಆಡ್ ಇದೆ. 700 ಅವರಿಗೆ ಕೊಡಿ. ಅವರಿಗೆ ಕೊಡಿ.
Ombudsman annexure L, Ombudsman ಸಾಹೇಬರ ಆರ್ಡರ್. ವಾಲ್ಯೂಮ್ ಕೊಡಿ.
ಅದು ರಿಪೋರ್ಟ್ ಆಗಿರ್ಬೇಕಲ್ಲ, ಅದು BCCI ಜಜ್ಮೆಂಟ್.
Judgment is reported 2016.
ಶ್ರೀನಿವಾಸನ್ ವರ್ಸಸ್
Srinivasan.
ಅದಲ್ಲ.
Apart from, my lords, the other aspects of IPL, there was a controversy. But with regard to this, my lords, it is.
ಆ ಸೈಟೇಷನ್ ಕೊಡಿ, ಅದನ್ನು ಓದ್ಕೊಂಡ್ಬರ್ತೀನಿ.
Lord, I'm sorry, may I just assist the ombudsman order in my site is shown as page 627, my lord. Perhaps if some pagination, there may be some variation.
Petition copy alliದೆ. Petition copy ಇಲ್ಲಿ ಇದೆ ನಂದು.
ಇದೆಯಲ್ಲ ಇಲ್ಲಿ 627 ಫಸ್ಟ್ ವಾಲ್ಯೂಮ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
Yes, my lord. Perhaps there is some overwriting to say 700.
Overwriting ಅದು it was
Maybe because of
twice
that, my lord.
changed, my lords.
ಹಾಲು
Sorry, my lords. Para 34, please, my lords.
T4
Also.
Point number 2.
Point number 2. Point number 1, please, my lords, is about the electoral officer and the ombudsman. We do not dispute that, please, my lords, because we write the grievance there. May I read, please, my lords? I shall not take up for consideration the questions whether all or any of the respondents 1 to 5 are hit by any disqualifications set out in Rule 6A and or Rule 6B of the bylaws of KSA, whether they are required to demit the post held by them in the managing committee of KSA, whether all of them, all or any of respondents 1 to 5 cease to hold the office which they are holding as set out in Rule 6E of the bylaws. I shall take up all these questions for consideration together in relation to each of the respondents in seriatim, one after the other. Respondent number 1. At notice supra, according to the complainant, respondent number 1, who is presently honorary treasurer, has cumulatively completed 9 years in KSA administration from 2007 to 2010 and 2013 to 2019, and therefore he has to demit office on 30/11/2019. Respondent number 1, in a statement of objection at para 4, has stated that in 2007, after the elections to the office bearers and MC members of KSA, the newly elected governing body nominated him as a member of MC under Rule 15C of the earlier bylaws, and he served as such till 2010. At para 5, respondent number 1 has further stated that similarly in 2013, after the newly elected MC was formed, he was again nominated as member of MC for one more term. At para 7, it is stated that in 2016, when the term of 2013 elected in MC was coming to an end, the KSA called for annual general body meeting to be held on 7/8/2016, in which elections for electing new committee for succeeding term 2016 to 2019 was to be held. However, the complainant, along with 2 other members, wrote to the Secretary of the Supreme Court Committee on Implementation of Justice Lodha Committee's recommendation, seeking issuance of direction to KSA to hold elections only after implementation of Justice Lodha Committee recommendations, and consequently, Secretary of Supreme Court Committee wrote to KSA directing it to keep future elections and process on hold pending further directions from the said authority. In the light of this, elections were kept on hold, and the existing body.
Who are office bearers means?
Office bearers, definition, how they give it is that president to secretary, vice president to treasurer, and so on, and they are the other elected members of the managing committee. But cohesively, my lords, what the Supreme Court defines is, Supreme Court defines it as a one body called the Apex Council, consisting of these persons.
Whichever be the nomenclature.
Yes, whichever be the nomenclature. They consist of one single body, that is called the Apex Council. And that is there, please, my lords, in the annexure, I will point out. Now, were kept on hold, and the existing governing body elected in 2013 was compelled to continue in office till the election. Thus, respondent number 1 continued as nominated member of MC till 2019, when the elections for the next term were permitted to be held. Thus, from the above, even according to the respondent number 1, he has served as nominated member of MC 3 years from 2007 to 2010. Thus, in all, for 9 years, admittedly in the election held on 3/10/2019, respondent number 1 contested for the post of treasurer and got elected. In the light of the above facts, let me mention and whether he ceases to hold the office of treasurer in terms of Rule 6E of the bylaws. Rule 6A 3(2) Roman 2 deals with disqualifications of office bearers. Portion of this rule relevant for our purpose is as under. Rule 6, election, term, and qualification. Office bearers. Disqualifications of office bearers. A person shall be disqualified from being an office bearer, a member of the governing council, or any committee, subcommittee, or a representative of the BCCI, or any similar organizations if he, she, A to E, has been an office bearer of BCCI for a cumulative period of 9 years or of a state association for a cumulative period of 9 years. Explanation. The period of 9 years contemplated above for the BCCI and the association is mutually exclusive. Thus, it is clarified that the person may be able to serve for a period of 9 years in the BCCI.
Which you read, that is 18 years.
18 years.
No.
And
Separate, they are mutually exclusive anta you agreed.
Howd.
Come to
9 years ಆದ್ಮೇಲೆ state association ಅಲ್ಲಿ he has got to contest at BCCI. He can contest. There is
here,
no bar.
here he is out.
Here he is out. He state association beyond 9 years, there is no term, there is no position at all that he can hold. The threshold bar is 9 years.
Maximum period he can be an office bearer is 9 years.
9 years. He himself concedes that he was nominated for 3 years and thereafter he has come and contested and been elected as the treasurer for the next term, ensuing term. So it will go beyond 12 years. Antandre, we are virtually diluting the Honorable Apex Court's the intention. Intention was to stop these people at that place. Stop them beyond 9 years, stop them. Otherwise, concentration of power. Then, my lords, all other things follow. Thus, from the above rule, it is to be noted that qualifications set out in Rule 6A are referable to an office bearer. The term office bearer has been defined in Rule 1CC to mean honorary president, honorary vice president, honorary secretary, honorary joint secretary, and honorary treasurer as per Rule 14A. Rule 14 deals with the managing committee, and as per this rule, the association.
All this matter on Monday, this matters is out. 25th. Tuesday, Wednesday, tax. Service matter ಜಾಸ್ತಿ ಇದೆ. Monday ಒಂದು ದಿವಸ ಹಾಕಿದ್ ಸಾಕು. Monday, Tuesday ಸರ್ವಿಸ್, Wednesday tax, ಆಮೇಲೆ Thursday, Friday ಬೇರೆ ಬೆಂಚ್ ಗಿಂಚಿಗೆ ಹೋಗಿ. ಹಂಗೆ ಮಾಡ್ತೀವಿ. ಮಂಡೇ ಹಾಕ್ಬೋದಾ? ಮಂಡೇ ಹಾಕಕ್ ಬರಲ್ಲ. ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸಿ Tuesday. All right. Coming Tuesday ಹಾಕ್ಬೋದು.
Please.
Great.
ಇಷ್ಟೇ ಪಾಯಿಂಟ್.
ಅಷ್ಟೇ.
It's a very
narrow and compass.
ಅವ್ರ ಆಫೀಸ್ ಬೇರರ್ ಆಗಿದ್ರ ಇಲ್ಲೋ, ವೆದರ್ ಕ್ಯುಮ್ಯುಲೇಟಿವ್ಲಿ ದೇ ಹ್ಯಾವ್ ಸರ್ವ್ಡ್ 9 years.
The rule
two questions.
Rule book calculate is 9 years.
ಆ 9 years ಆಗಿದೆ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ಆ 9 years ಇಬ್ರದ್ದು ಆಗಿದೆ.
ಆಮೇಲೆ ಬೇರೆಯವ್ರದ್ದು
ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಅವರಂತೂ ರಿಸೈನ್ ಮಾಡಿದ್ರು subsequently, but while holding office of a government post he did not resign. That is the reason we have come up before the court. And that's paragraph 24 ಅಲ್ಲಿ ಇದರಲ್ಲಿ writ is maintainable, 226 is maintainable ಬರ್ದಿದ್ದಾರೆ. That I'll demonstrate.
Well, even he said that one, but anyway, in different fat matrix, we'll consider that also.
So very great.
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 ಬೇಗ ಓದೋದೇ ಫಂಕ್ಷನ್ ಇದೆ.
You want to connect it
want to connect to the laptop server, there is a password.
Sir, ಇದು
Down to the this matter is.
ಅದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೇಳಬೇಕು. ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 30. Serial number 32. Serial number 32. 30 next to